Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a truly wonderful day. We're here with the Maya Kowalski case of November the 6th of 2023 to try to provide a little bit of a roundup for some of the key segments that happened today during the trial. So it was supposed to be closing arguments, but that didn't happen. We got stuck in other things. Closing arguments are now scheduled to occur first thing this morning, but the jury has received their jury charge. We did hear a little bit of a rebuttal case, and we also heard some other hijinks that were interesting, and we can talk a little bit about as they pop up, and we can go from there. So, should be interesting. Let me see if I can do something about this light issue, because it's kind of off. There we go. That's better. All right, so anyways, let's talk about some of the things that happened today during the Maya Kowalski trial a little bit. So we'll start this morning with the motion practice. So over the weekend, there was this issue that Johns Hopkins witness got on the stand and basically said in so many words, Johns Hopkins is a wonderful hospital. Nothing ever goes wrong there. It is truly a wonder of joy and light. And specifically, the Joint Commission has no problems with us and never did. And there are no problems here. What are you talking about? We're great in every single way. Well, plaintiff had some information that was contra to that. And so there was an issue of what was going to come in about that. So we're going to summarize the issue. We're going to summarize the issue in terms of what happened today in sort of the motion hearing, and then we'll listen to some other stuff. So this morning with the motion hearing, Johns Hopkins started right away with just whining. And they were just whining right off the bat, right? They're whining about the whole thing. And they said many, many contradictory things, not for the first of times, of course, because Johns Hopkins' testimony has at times been incredibly contradictory and all over the flap. So they first of all said, well, everything our witness said on the stand was true. Everything they said on the stand was true. You know, when they said there were no problems with the Joint Commission, what they meant specifically was the time that Maya Kowalski was in the hospital. There were no problems at that point. You know, so what they were saying was true because they were talking about that time period. Also, we'd like to strike our testimony, which doesn't make any sense, by the way. It doesn't make any sense. Because, and then the judge is like, but why? Right? Why do you want to strike the testimony? This is your witness, right? This is your witness. You want to testify. It's not that they perjured themselves, right? Because if they perjured themselves, if they testified falsely, you have to correct that. A lawyer has a duty to correct that. So it's like, you know, it turns out our witness lied, and we need to remove that from the record because we've unintentionally offered false testimony before the court, and we're under an obligation to correct that because we have a duty of candor to the tribunal, right? But they didn't say that. They didn't say, well, our witness lied, and so we need to strike their testimony because it turned out not to be true. We need to step back from that. They say, nope, there's no problems here. Our witness is completely correct, and everything they said is full of glory and light. Also, we'd like to strike their testimony. Okay, this doesn't make any sense. Maya Kowalski's team, on the other hand, apparently not realizing this gift they had, then tried to commit an unforced error. So Maya Kowalski's team gets up there and argues, you know, well, we want rebuttal. We want the ability to offer rebuttal testimony. They offered lies. We want the opportunity to bring in stuff to show that they have made false statements. We would like to attack the character of their statements. You know, we'd like to challenge that by offering rebuttal testimony. That sounds great. And then they said, but in the alternative, we're okay with striking the testimony. And it was about at this point I started to question the wisdom of Maya Kowalski's attorneys, and not for the first time. And not for the last time today. Because I'm like, this makes no sense. You know, you want to strike the testimony? You, Maya Kowalski, want to strike their testimony. The thing that has opened the door for you. The thing that's opened the door for you. The thing that has rung the bell. You want to undo that. You want to unring the bell. You want to close the door. This makes no sense. Why are you doing this? And then Johns Hopkins, for their part, apparently not noticing the unforced error, didn't leap on the football like it was the greatest gift of all time, right? Johns Hopkins is over here just literally fumbling the football. It's sitting right there in the open field. They apparently don't know what to do about it. It's just been fumbled, sitting there on the grass, waiting to be picked up. And John Hopkins is over here looking at the ball, or apparently doesn't notice it's been fumbled or something somehow. And it's like, well, we're if they, we don't think that they should strike, but we don't want rebuttal testimony. It's like, dude, what is your position over here? Like, what is your position over here, Johns Hopkins? They just committed an unforced error. Like, what you should be saying at this point, all right, what you should be saying is some version of, plaintiff counsel is best counsel. We thought we were good counsel, but plaintiff's counsel is best counsel. The other side has truly shown us up. And they have shown us up in this glorious suggestion that the testimony should be stricken. Wow, why didn't we think of that? Why didn't we think of that? That's plaintiff's counsel is truly the best and wisest counsel. They're glorious in every single way. Everything they say is wonderful. And Your Honor should absolutely do that. Your Honor should absolutely strike this testimony and remove it from the record. Wow, we couldn't believe it more. We bow at your feet of our unworthiness. We're not worthy. We're not worthy. We bow to the wisdom of your suggestion, Your Honor. Best suggestion we've ever heard. We also would like to strike the testimony. But they didn't say that. They didn't say anything like that. They apparently didn't notice the football had been fumbled. They apparently didn't notice that the opposition agreed to exactly their suggestion. And just decided, okay, I'm not gonna take the football. So now we got a football that's just sitting in the middle of the field, and neither side is doing anything with it. The play hasn't been called dead. The referee hasn't blown the whistle. The football is just sitting right there in the middle of the field, and plaintiff's counsel has fumbled it and apparently doesn't know how to pick it back up again. And defense counsel doesn't notice it's been fumbled, and they're very confused. Everyone's very confused, and everyone just looks at the football, and maybe it will move itself. Well, it doesn't seem to be moving itself. It just seems to be sitting there, waiting for anyone to pick it up at any time. So it's about this time that the judge looks at plaintiff's counsel and be like, yeah, are you sure? You sure, Maya's team, that you want to strike it? Are you sure? Because that doesn't make any sense. Because then you can't have rebuttal. And plaintiff's counsel looks all confused. What do you mean we can't have rebuttal? Well, you see, you want to move to strike the testimony, right? Right. And you want an instruction to the jury to disregard the testimony, right? Right. Okay, well, at that point, the testimony didn't happen. Because that's what you just asked me to do. You just asked me to strike the testimony and give a cautionary instruction to the jury. Hey, members of the jury, you remember that testimony? No, you don't. Never happened. And as a matter of law, that means it never happened. Because as a matter of law, we have confidence that the jury will follow the judge's instructions. Of course the jury will follow the judge's instructions. They always follow the judge's instructions, don't you know? This is our legal conceit. Okay, as a matter of law, of course the jury will follow the judge's instructions. Why would they do anything else? Of course they're going to do it every single time. So the judge is sitting over here. It's like, look, if I strike the testimony and if I give an instruction to the jury to disregard, the testimony never happened. And the jury will be like, what testimony? We don't remember any testimony. We've completely forgotten it. We have blotted it out of our minds because it never happened. So you want to give rebuttal to what now? You want to give rebuttal to what now? The testimony that never happened? How do you rebut it when nothing happened? You can't react to something that never occurred. Right? You want to go back in time and you want to undo the action. You can't have a reaction without action. You understand how this works? So you want to go back in time and undo the action. And you're like, we'd like a reaction, please. To what? So the judge gives 5 minutes. So the judge basically lays it out for them because apparently Maya's attorneys have gone full dum-dum over here. And they don't understand this. So the judge has to lay it out for them. It's like, okay, counsel, you have 2 options. Let me spell it out for you. Option number 1, I grant the motion to strike. I grant the cautionary instruction. You can't have rebuttal. Because there's nothing to rebut. Because the testimony never happened. Because that's what you just asked me to do. That's option number 1. Option number 2, the testimony stays on the record. I don't give the instruction. You can have rebuttal. Because now the testimony has occurred. So which of these options do you like better? Do you like option A or do you like option B? Which do you like? And at this point, the attorneys for Maya say, can we have 5 minutes to talk about it with appellate counsel? Which to me is like, this is obvious. The answer's obvious. You want the rebuttal. You want the rebuttal. You want the ability to bring in the testimony that says Johns Hopkins is a bunch of liars. Of course you want the rebuttal. It's your door to bring in all this testimony that you couldn't bring in before. Right? You have all your expense on this. The only expense is Johns Hopkins self-serving testimony that we're a great hospital and we didn't do nothing wrong. So the only sort of contra to this is Johns Hopkins themselves say we're great. Well, of course they say they're great. What else would you expect them to say? So that doesn't really go very far. And now suddenly you have this wonderful avenue to bring in all this testimony you couldn't otherwise bring in, because now it's suddenly relevant because you're using it to rebut their self-serving statements. Well, I need 5 minutes to talk about it with appellate counsel, who's also in the room, incidentally, which I find mildly hilarious. I need 5 minutes to talk about it with appellate counsel about which of these doors I like better. Even though the answer seems obvious to me. So they go have a 5-minute powwow about it, and then they come back, it's like, upon further consideration, I'd really like that testimony still on the record so that I can have a rebuttal. And the judge is like, that was the right answer. He didn't say that, but you could see it in his eyes. Like, that was the right answer. It's like, I am feeding it to you. It seems obvious, but yes, you've picked the right answer. Great. So then they spend 45 minutes talking about exactly what testimony they're going to bring in, all right? So the judge basically gives this instruction. He's like, okay, what I want to do is I want to have a sort of a 30,000-foot overview kind of rebuttal. Okay, Johns Hopkins has given a statement, we didn't do nothing wrong. The commission has no problem with us. We're a great hospital and everyone loves us. All right, so what I want you to do on your side is to give statements that are in direct opposition to that, but of a similar sort of scope, right? Sort of general, global stuff, right? And what the judge talks about specifically is that he wants to avoid this turning into another mini trial or like 30 mini trials. This is what the judge wants to avoid, right? Because he doesn't want to get to Miss Jones, who doesn't exist, but let's pretend she does. He doesn't want to get to the case of Miss Jones, who in this hypothetical is some patient who went to the heart clinic and had a stent put in her heart the wrong way, and it went bad, and Miss Jones died. Right? He doesn't want to get into the particulars of Miss Jones's case, or Miss Rose's case, or Miss whatever's case. He doesn't want to get this into the particulars of all these cases because he doesn't want to turn it into 30 or 60 or 90 or whatever, like mini cases, or even one mini case, right? We're talking about Maya Kowalski. We're not talking about hypothetical patient Jones's heart stent, right? We don't want to do that. So I want you to give a sort of global view of this in a global way. Plaintiff's attorney, apparently actually understanding the assignment for once, so that was a nice touch, say, okay, we want to introduce 7 documents. That's all we want to introduce, 7 documents. And the judge looks right away, and you can just see it on his face. That was the right answer. That was the right answer, right? It's not that I want to bring 70 documents in. It's not that I want this to go on for weeks and weeks and weeks more. I just want to bring in 7 more documents, just to bring in these documents to highlight the idea that Johns Hopkins sucks. Great. So the judge is right away, it's like, great, you understood the role, you understood the assignment. Keep it simple, stupid. Don't overextend your welcome. They understood it perfectly. And then they dick around about redactions for a while to take out specifics. They take out specifics of patient names and stuff like that. And also, I think that they globally marked out all references to the heart clinic specifically, and they also marked out any references dealing with someone's death. Because again, we're not here to adjudicate hypothetical Miss Jones's death. We're here to deal with Maya Kowalski, right? Miss Jones can bring her own lawsuit or not, as she pleases, for whatever, role she wants. But we're not here to fix that. And we also don't want the jury to hear about Miss Jones's case, because then if the jury awards damages, we're not sure for what, right? Are they trying to punish Johns Hopkins because how they screwed over Miss Jones, right? That's not this jury's role. That's some other jury's role maybe, but not this jury's role. This jury's role is to figure out whether or not Johns Hopkins screwed over Maya Kowalski. So it's like, okay, we're going to take out any references to the heart clinic. We'll take out any references to patient's death, and we'll just deal with these global statements in a sort of global way. Fantastic, right? So then they dick about that for a while, and that takes us to lunch. Okay? So that's where we are. So we are going to now watch the cross-examination of the rebuttal witness, okay? Because it's the interesting thing for me, right? So the direct examination of the witness didn't go on very long. It was actually kind of short and tight, which I appreciate. It was very simplistic and basically amounts to, yeah, Johns Hopkins has some serious problems. They have had these issues. At one point, they were given this immediate advisory action, this imminent action, which is basically like a death sentence for a hospital, because it's, if you don't fix it right away, all your funding goes bye-bye and you close. So, there were some serious problems with the auditing and stuff like that, and there was this immediate action problem, and there was all these other things. So, they basically opened up the concept. They didn't overstay their welcome, which was appreciated. They just got in the concept that Johns Hopkins, maybe not all is right in the world. Not all is right and great and glorious. So that's what they got in, okay? So that's direct, and we will watch the cross-examination together. We're going to watch it at 1.25 speed, but you can listen to the cross-examination because it's kind of hilarious. And also the witness does a pretty good job of taking the attorney to task and beating the attorney up, which I appreciate. So we can watch this expert witness holding his own as Johns Hopkins on cross now in this segment desperately tries to, show that they're a good hospital that knows what they're doing.
You were provided a number of documents regarding various surveys, correct?
I saw several documents that involved surveys, yes, sir.
Were you given a set of documents regarding a Joint Commission triennial survey from September of 2015?
I saw the summary of it, yes, sir.
That resulted in the Joint Commission accrediting the hospital, did it not?
In 2015, yes, sir.
All right. And that accreditation was good for the following 3 years unless it was revoked, correct?
That's correct.
All right. And did you also see a survey, and incidentally, these surveys are fairly arduous events, are they not?
Typically, you've got 3, 4, maybe 5 surveyors on site for 3, 4, or 5 days, yes, sir.
When you were at Brandon Regional Hospital, did you handle those?
I was absolutely involved in every day that they were on site.
Very searching review, correct?
They were stressful, yes, sir.
All right. They went to all aspects of the hospital, correct?
They did.
All right. So when they did that at Johns Hopkins All Children's Hospital in September of 2015, they reaccredited the hospital, correct?
Yes, sir.
And then in 2016, they did a follow-up random review. You saw that, did you?
Could you refresh my recollection on that, sir?
Sure. Wasn't there in March of 2016 a follow-up review of evidence of compliance with the accreditation they had been granted the year before, in March of 2016?
Proper way to refresh recollection. Right. If you're going to refresh his recollection, once you show him the document.
Let me get that.
Yeah, that would be great, right? So the doctor said, so he asks him, okay, were they accredited in 2015? Yes. That's a 3-year accreditation. Yes. Okay, were they accredited in 2016? He's like, I don't know what you're talking about. Could you refresh my recollection? What are you talking about, sir? And then he starts to ask a question about it, and the counsel just gives the appropriate answer. Like, that's not a proper way to do it. If you want to refresh his recollection, show him the document. Just show him the document, right? He's an expert. He's like, I don't know what you're talking about. Could you help me out? And he doesn't show the document. It's like, so amateur hour over here sometimes.
Hold up, Judge. Let me ask a couple questions first before I do that.
Let me ask a couple questions before I do that. Now, now would be a good time, by the way. You want to ask a couple questions about the thing he doesn't understand. He doesn't know what you're talking about. But you want to ask a couple questions about it. Sure you do. Okay, great.
You were present during Ms. Green's deposition the other night, right?
I was there. Yes,
and
sir.
were you provided a copy of the review done by the Joint Commission in March of 2016?
Mr. Hunter, I can't say with certainty that I was. It was Parents' Weekend at my son's college, and I was up in Gainesville. So I played dad instead of expert witness this weekend. I can't tell you which documents, off the top of my head, which documents I saw and which I did not. I certainly did not see but a small fraction of what was turned over.
Okay. Well, did you see a risk management survey that was done by ACA in February of 2017?
Again, I'd like to have my recollection refreshed. I don't recall which ones I've seen and which I didn't see.
Did you see?
Just hand them the document if you.
Judge, I'm sorry that there's a stack of documents that would gag 3 billy goats and a maggot about this tall.
That is the stupidest thing I've ever heard in my life. Okay, so he says, just give him the document for the second time. And what does counsel say? What does counsel say? Oh, Your Honor, that's so inconvenient for me. I have a stack of documents this tall. I don't know where the document is. What are you talking about? You're asking this expert to remember a specific document that he saw this weekend. Okay? And the expert's like, I don't really remember seeing that specific document this weekend. There was a deposition and we were reviewing a lot of documents, but I can't quite remember the specific document that you're talking about. Could you show it to me? No, I can't show it to you because I myself can't find it. But you want the witness to remember it. So let me get this straight. You want the witness to remember the document that he saw, but you can't be bothered to provide a copy of it because it's lost somewhere in the mountain of documents that you have that he saw. And you're like trying to imply the witness is being deceptive with you or evading you when he's like, I saw a whole mountain of documents. I don't remember if I saw that document. Do you know where it is? No, because it's lost in the mountain. I can't be bothered to have the document I'm asking you about right now. I don't know where it is. Why can't you remember what the document is, sir? Why can't you remember it? Where's the document? I don't know where it is. Why can't you remember it? It's amateur hour over here.
What that means?
Well, it's a lot of documents. And I don't have at my fingertips the ability to grab that particular document.
Do we need to take a few minutes?
You don't have it at your fingertips to grab that particular document, but you expect and are annoyed that this witness can't just grab the document from his mind. Okay.
So you can organize.
It would be very helpful, Your Honor.
Why don't we take 5 minutes? Members of the jury, do not discuss this case amongst yourselves, do not do any investigation, and receive no information.
All right, so now we're going to take a 5-minute break while we hunt for the mysterious document, which may or may not exist, right? Who knows? Because we don't have the mystery document. So, but the witness should absolutely remember the mystery document. He saw it this weekend. Of course he did. He should remember it off the top of his head, but I don't know where it is. It's lost in my mountain. Yeah. The stupid hurts sometimes, guys. The stupid really hurts sometimes. We were all spoiled by Johnny Depp's lawyers. Johnny Depp's lawyers always knew exactly where the document is. Every time Camille Vasquez is like, do you remember the document? And the witness said no. And she's like, that's okay, I'll get it to you. By the time she walked the 10 feet from the lectern back to counsel's table, it was in her hand.
Yes, sir.
Ready to go?
Yes, sir.
Let's bring back the jury. Yes.
So it's not hard, you know? You just have to, like, you know, be organized and stuff. It can be done.
Please be seated, everybody. Members of the jury, I want to confirm while you're away, you did not discuss this case amongst yourselves. You did not do any investigation and receive no information. Is that all correct?
Correct.
No one approached you about this case. Is that correct?
Correct.
And you didn't see any media coverage. Is that correct?
Correct.
Mr. Hunter?
Yes, Your Honor. May I approach witness?
You may.
Do you have the document now?
Accreditation report here
Hold
from
on.
Thank you.
March of 2000.
Yeah. Okay. You want to come in? I'm streaming. I can't get up. Can you come over here?
Should I crawl down?
You don't have to, Mom. It's okay.
Okay.
Hold on. Okay. All you have to do is hold down the flashlight button.
Yeah.
Just press it and then release it.
Oh, okay.
Yeah.
Thank you.
No worries. Okay.
Sorry.
No worries.
That was an emergency.
We love you, Mom.
Thank you.
You're welcome.
2016. You ever seen that before?
I don't believe so.
So, you've never reviewed what I just showed?
I don't believe I've seen this particular report. Yes, sir.
Can I really approach for a moment?
Sure.
So now they're approaching about the document because apparently there's some confusion.
Where you were provided a number of documents, or you attended a deposition Friday night?
I did.
Okay. And there were a number of documents that you got to see as a result of that, correct?
Yes, sir.
Okay. The one I just showed you, you said you'd never seen before.
I don't recognize it. It may have been introduced, but I don't recognize it.
Well, my question to you is, do you have any reason to question the proposition that in March and April of 2016, a joint commission survey occurred unannounced at all children's hospital and their accreditation was affirmed?
Objection. Counsel testifying.
Overruled. You can answer.
I'm sorry, can you repeat this question, please?
Yes, sir. Do you have any reason to question that in March of 2016, followed up in April of 2016, a joint commission survey took place at Johns Hopkins All Children's Hospital and that their accreditation was affirmed?
So I have no reason to question you, and that if accreditation was renewed in 2015, then unless there were a flagrant violation, the accreditation would not really be on the table at that time.
Well, wouldn't there be occasional random follow-ups to accreditation inspections?
Short answer, no. Most of the time, Joint Commission returns to a facility in response to a complaint or awareness of some kind of a problem.
So you've never heard in your long experience of random surveys taking place after an accreditation in the preceding years?
Objection. Argumentative.
Overruled.
There can be follow-up surveys. When the accreditation survey is done, then CMS actually audits the work of the Joint Commission and will come in and do, I'm blanking on the term for it, but they will basically come in and affirm that the Joint Commission survey is accurate.
Okay. The document I just showed you.
My mom, by the way, just FYI, my mom just got her first cell phone ever in like the past couple days. So, as you are apparently, as you guys know, my brother had a daughter, and so my brother's like, well, you know, we could share photos with you and stuff, but you don't have a phone, and so she wouldn't get a cell phone for me. She wouldn't get a cell phone for us, but she'll get a cell phone for the grandbaby. So yeah, she has an iPhone, and it's her first cell phone she's ever had ever, and she's had it for about 4 days. So, just by the way, that's where we're sitting.
You was a Joint Commission survey, correct?
I believe so, yes, sir.
And you have no reason to question that it affirmed the accreditation?
Well, I don't think that was in the time frame. Typically, CMS comes back in 45 days or less. So I don't think that's the kind of survey that I was referring to, sir.
All right. Well, let's go with this another way.
May I, if you'll show me the document, I'm happy to do a quick review of it.
Well, I'll be happy to show you this and the two.
So up to this point, he still has not seen the document, right? He still hasn't seen the document. So he asks him, don't hospitals get random reviews? And he's like, no. In your long career, you've never heard of a hospital getting a random review? No. No, they sometimes will follow up on specific complaints or specific issues, but they don't do random spot inspections. No, never heard of that. Do you have a document? Can I see the document? We're still doing amateur hour over here, by the way. Still doing amateur hour over here.
Follow-ups from these complaints.
Just the three, or is that it?
This is different.
Okay. Can you give me a minute to look at them?
Sure.
Okay.
Perhaps, Mr. Hunter, you could return to the lectern.
So I'll go back there. Go back there. Go back to that lectern.
So on the survey done March 7th, which was unannounced by the Joint Commission, they found elements of performance where there was insufficient compliance. Social work consult for a patient on suicidal precautions was not performed until approximately 9 hours after. There was another element of insufficient compliance that related to utilization of moderate or deep sedation or anesthesia.
And were there, were there indications of a follow-up that established compliance?
I'm looking for that in the next visit, sir.
So now the counsel has just handed, so counsel for Johns Hopkins has just handed the witness a document that further exposes problems at Johns Hopkins. Well, I can't help noticing that this document reflects this problem, this problem, this problem, and this problem that Johns Hopkins was having. That's the document you just gave me just now. Wow, look at all these documented medical problems in the document you, Johns Hopkins lawyers, just handed me. Look at all these problems in this document.
You just want to match up the ECLD. So this visit that was approximately a month later is a survey addressing different elements of participation, different standards.
And it indicated compliance.
This shows compliance. This still has some outstanding issues.
Oh, outstanding issues, you say. How interesting.
There's a subsequent that shows that that was placed in compliance, correct?
1 second, sir. So this survey, dated 4/22, which is the 45-day evidence of standards compliance, does show compliance with the anesthesia-related fallout, but not the leadership one. And this one, dated May 3, the 60-day visit, does show 040, LD 040105 is now compliant. So from March until May, they had issues and they corrected them.
Thank you for the stripe donation.
Joint Commission surveys, is it not?
Yes, sir.
Happened in your hospital, didn't it?
Many times.
But we're not talking about your hospital. We're talking about
incidentally,
Johns
there's a
Hopkins,
number
your
of
hospital.
ACA inspections of your hospital, correct?
ACA is a frequent visitor to most hospitals, sir.
Frequent visitor to Brandon Hospital, correct? For complaints and otherwise.
I will tell you, during my tenure, they were frequent but not overwhelming.
Now, isn't it also true, sir? Well, let me just ask you this way: you were given a report of an unannounced accreditation survey by the Joint Commission of Johns Hopkins All Children's Hospital in August of 2018?
Unannounced in August of 18. Wasn't that when they had their re-accreditation visit?
Yes, sir. Yes, sir.
And there was a second visit
Yes, sir.
the same month?
Yes, sir.
I don't believe I saw that one.
Okay. But those visits resulted in reaccreditation, did they not?
Not the second visit. That's not a reaccreditation. They were reaccredited in August of 18,
Okay.
but that was their triennial review. Yes, sir.
So the point I'm making here is that in August of 2018, there was a triennial reaccreditation survey done by the Joint Commission that resulted in reaccreditation, correct?
Right, and all of the violations were on the safer matrix in the lower, less frequent quadrant.
That's where you want them, right?
Amen.
Okay. So in August of 2018, the 3-year accreditation that was issued in September of 2015 was continued, correct?
Somewhat surprisingly, yes.
Somewhat surprisingly, it was still accredited.
Editorial comment aside, it was continued, correct?
Well, again, given the presence of ACA Joint CMS starting in April of that year, yes, they got away with a remarkably benign evaluation, and it was, in fact,
And it indicates
reaccredited.
effort on their part to do that, correct?
Okay.
I love that simple okay. I love that so much. It's so dismissive and so perfect. It's like, okay, I was surprised that they were so easily accredited. I was surprised. You know, so given everything they went through, they had a remarkably benign review. Well, isn't that just normal? Okay. Okay. And it's like Johns Hopkins, anytime you want to stop hitting yourself will be just fine, guys.
Incidentally, were you provided information regarding a CMS survey of all children's in May of 2017?
Again, can you show me the documents? so I
Sure,
can
I'm showing the
refresh?
witness trial exhibit 2823-001.
Please show me the bullshit documents you're relying on. Let me tell you how they don't say that.
Yes, this was a visit specific to the pharmacy.
Show compliance, correct?
I believe there were no issues identified on that visit.
Okay. Now, let's talk for a minute, if we could, about some of the reports that counsel walked you through. Let me first have direct your attention to trial exhibit 2811. You can put that up there. I'm not sure we need to see the details of it, but was there any indication in that report? You reviewed this, right?
I did. This today.
Okay.
Yes, sir.
You testified about this a few minutes ago.
I did.
For counsel.
Yes, sir.
Okay, so were you aware of any joint commission survey of the hospital being done at the same time or around the same time as this particular report?
I'm struggling to answer clearly because there were so many surveys. Candidly, Mr. Hunter, keeping ACA from CMS is a challenge given the short timeline in my cursory review of just a part of the documents that you shared.
Well, let me show you what I'll represent to you as a joint commission correspondence from Mr. Sowers dated February 25th, 2019. Were you ever shown that?
Yes, this is a letter that documents the acceptance of the conditions of the plan for corrective action from the IP. Is that correct?
I believe you'll see
from the IJ. Sorry, the immediate jeopardy.
I believe you'll see that that indicates that there was a survey done by Joint Commission at or about that time that resulted in a finding of compliance.
Yes, the services at your hospital were found to be in substantial compliance.
That was a Joint Commission survey that occurred, correct?
And that was done 1 month after, or 23 days actually, after the IJ. And 23 days is kind of that magic window that if you're not in compliance by then, you are at risk for losing your funding.
Glad you brought that up. So the IJ was issued by CMS, correct?
Correct.
All right. This is the Joint Commission.
Right.
They're not the same thing.
They're not.
Okay.
The IJ, by the way, is immediate jeopardy or imminent jeopardy. It's basically like the ultimate red flag for the hospital. Anything higher than that, and it just results in an immediate takeover of the hospital because conditions are so bad. But IJ is what has been referred to before as like the financial death penalty, because you have an immediate, imminent problem that requires imminent fix because it's causing a problem right now to basically people's health. So it's a super duper big deal. It's a really big deal. Like, these are manifestly unsafe conditions that are causing immediate threat to patients. And so, yeah, that's the thing they're talking about, is this IJ. Johns Hopkins not getting always glowing reviews, by the way.
The Joint Commission found that there was substantial compliance, and the CMS was in the process of following up on the IJ, correct?
So it gets even stickier because the CMS surveys are typically handled by ACA surveyors.
Okay. Well, whoever was doing that, they lifted the IJ at about this time, February 25th, did they not?
They lifted the, well, no. What they did at that time was that they accepted the corrective action plan. The IJ threat was still in place until, I believe, late May or mid-June of that year. And in fact, the hospital requested and was given 2 extensions to comply, and then ultimately had signed an agreement, a binding agreement with the federal government that it would accept having a consultant in the facility for the next 12 months who would oversee or direct the compliance, and in exchange, the federal government takes the threat of losing funding away.
But the IJ was lifted.
Again, they accepted the plan of correction.
You hear that little sigh? No. Like, I just answered this, but you didn't hear me the first time. Right? No, the IJ was taken away. No. They accepted the remedial plan. It isn't the same thing. Okay? It's a step towards the IJ being removed, but it's not the same thing as the IJ being removed. Right? There's a couple steps in the IJ being removed. There's the immediate thing, which, as they testified in direct, is usually done before the people who note the thing leave. Right? So before they even leave, there has to be correction action taken because it's imminent. Okay? Then, within 23 days, they have this plan to like further remediate it, but that doesn't remove the IJ either. He just told you the IJ wasn't removed until like June. What are you not understanding? The IJ was removed. No.
Correct. And lifted the IJ as a result, correct?
No, sir, because again, they were still under threat of being removed from funding until late May or early June.
But at that point, the IJ was ultimately lifted, correct?
At the end of June, yes. I'm sorry. I thought you were asking about that February date.
All right. So we can
February
agree the IJ
is not in
was
fact June.
With an asterisk because of these
And we
extraordinary.
can agree that there was substantial effort put forth at compliance.
Oh, absolutely.
All right.
The new team actually did well.
Okay.
They worked hard.
Well, let me come back to that in a minute. In this 2811, where is the reference to nursing service?
This survey was conducted in conjunction with a risk management survey.
That's all. Just risk management.
From what you're showing me, yes, this is a risk management survey.
All right. Where is the reference to risk management activities in the fall of 2016?
There's nothing specifically mentioned about 2016 in this unannounced complaint investigation.
Now, there was talk about trial exhibit 2815. Let me ask you, get that up if you could, Clay. And you talked about the 4 areas that it addressed. And this is the announcement of the IJ in January 2019, correct?
January 31, 2019, yes, sir.
Okay.
So now Johns Hopkins, in their infinite wisdom, would like the jury to specifically consider the announcement of the IJ. Here is the official Proclamation of the IJ. Here are the things that were so bad they were causing imminent harm to the patients. Please put this document on screen. Please let the jury see it. I would like them to see the document that shows the problems Johns Hopkins had that were leading to imminent threats to the patients. This is Johns Hopkins lawyer.
And that's January of 2019 is about 2 years after Maya Kowalski was discharged, correct?
That's correct.
All right. Now, in this statement of the grounds and the findings that are based on the IJ, that were the basis for the IJ, where is the reference to the nursing service?
It's not in this letter. It's in the CMS 2567.
By all means, do you have that handy?
No, sir.
Do you have it handy?
Well, in this letter here, is there anything basing the action on the hospitalist service?
Medical staff.
That's such amateur hour. Do you have the document? Do you have the document? Do you have it handy? Lol.
Medical staff in general,
Right.
no specification to the hospitalist service.
Not in this letter. Again, this is the overview, not the detail.
Okay, so the detail is in the 11119 form
2567.
2567 in the lower left-hand corner.
Yes, sir.
Okay. So you looked at all 100 and some odd pages of this?
I did not see the version with the corrective action plan. I looked at the original document, which was 49 pages.
Okay. And I may have that in my hand too. I just can't tell the weight of these things.
Fair enough.
But I was curious, in looking at this document, did you see any specific reference to the PICU intensivist service?
The intensivist physicians were not specifically mentioned. No, sir.
Nor were the hospitalists, correct?
To my knowledge, no, sir.
All right. And you didn't see any reference to the pain management service either, did you?
No, but again, the issues that were cited are the ones that support them and also oversee them.
They
Right?
oversee them, but we're talking about them themselves, the people.
Yeah, and it's
Not the structure
unusual.
of the people.
So they themselves weren't cited, just their oversight was cited. Great. That's great. Really sell that distinction. That sounds great.
I understand your question now. It's unusual for specific physicians or specific medical groups to be identified in these kind of surveys.
And in that survey, did you see any reference to what was happening on the 7th floor, the medical surgical unit, in October of 2016?
Well, again, no, because the survey is not geared to follow specific physicians, physician groups, and their individual practices. That's a job that falls to the medical staff led by the MEC, and that's what was called out here. So more.
But there's specific examples given for most of these things. And so what I'm trying to find out is, did you see in this report, in the original report that put in place the IJ, or was the basis for what was put in place as the IJ, did you see any reference to the events of October, November, and December of 2016?
Specific to those dates, no, sir.
And you saw no reference to the psychology service specifically, did you?
That's correct.
And you saw no reference to the psychiatry service, did you?
For those dates, no, sir. You're correct.
Now, there was reference to your discussion of Trial Exhibit 2817. Hey, excuse me. See, she does it to me too. It sounded to me like you were saying that the problem, or one of the problems addressed
Can you put
here
that
was-
document up, sir?
Oh, sure. Can we put that up? I just got a couple of questions about it.
Sure.
Do you?
First of all, it indicated they were working to improve the situation, right?
Yes.
Okay. And in some of the documents you made that we were referenced here, specifically 2821A, You weren't asked about that one.
I don't recognize it by number.
2821A in evidence. You can put that up. Well, let me finish. Too quick for me. Let me just ask you first of all, before we leave 2817. It sounded to me like what you were concerned about in this document was the extent to which risk management was not reporting upward.
That was one of the talking points that they developed for the interim CEO to address with the board.
And they were trying to...
Was sharing of information, correct.
Okay, so information wasn't getting shared by risk management. Right?
That's the inference from their talking points.
All right. So let's go back, if we could, to what I was referring to a moment ago, 2821. This is a letter dated 10 February 2019 regarding the statement of deficiencies, right?
Yes, sir.
Okay. And this letter indicates, does it not, that efforts to address what later became the basis for the IJ had already begun by the time of the inspection, correct?
That's incorrect. This is February 10 of 2019. The survey was 10 days earlier. This is the response to it.
Understood. This is the response to the inspection report from January 11th to January.
Oops. No, it's not. It's a response after. That's how time works.
7th to
7
January
to
11th.
11.
And this was one time, submitted within 10 days, correct?
From the January 31 report back, yes,
Right.
sir.
And this letter summarized efforts that were being made to address the IJ concerns, correct?
It does, and as I said, the new team actually worked really hard. It was too late to help Maya, but this was good work.
The new team was already in place by the time of the inspection, correct?
They were assembling. I think Ms. Green actually took her role 3 or 4 days before 12 inspectors, surveyors arrived. But yes, sir, they were assembling. They were mustering.
But the executive team was already in place and already addressing these concerns by the time the inspection team arrived, correct?
I can't speak to the entire team. They had 8 departures in leadership, so I don't know that all 8 spots were backfilled. But I do know that there was an interim CEO in place. Regarding the other 7 positions, I have no idea when they were
You've shown us his talking points and the efforts that were being made to address the situation, correct?
Following the survey, yes, sir. And he was also one of the, per Ms. Green, he was also one of the attendees at the visits to CMS in Atlanta and ACA in Tallahassee.
May I have a moment, Your Honor?
You may.
You have a moment. This cross hasn't gone the way I hoped.
That's all I have. Thank you, sir.
Well, that was how well that went for Johns Hopkins. So I think arguably it was worse for them on cross than it was on direct. The direct was arguably not as bad for Johns Hopkins because we didn't watch it, but because we're just trying to show you some highlights, hence the name of the show. But it was very quick, all things considered. They didn't really belabor the point. It was about 40 minutes on direct. You know, it wasn't really extensive or long, and arguably was more damaging on cross. Because this witness is just like destroying them. And he's like, oh, I don't know what you're talking about. You know, I don't know what you're talking about. Random inspections. That's not a thing. That's not how that works. No, it was too late for Maya because the team sucked so hard. So the rebuttal was pretty effective for, pretty effective for Maya. And what's interesting about the whole thing, to my mind, is that I don't know because I'm not a doctor, obviously, and I haven't seen med mal cases like this. But if you told me that these kinds of reports were fairly typical of hospitals, I think I'd believe you. You know, I mean, you know, not everything's going to be perfect all the time. I'm not sure the degree to which people are getting these IJs, you know, but it's it's not like something that's completely unheard of either, right? So what strikes me as odd about the whole thing is like if Johns Hopkins had just admitted this up front themselves, then it wouldn't have been that big a deal. At least to me. I could be assessing the risks wrong because maybe it's worse than it seems, but it doesn't. It seems very manageable, and there's a very good rule on there's a very good rule in litigation that anytime there's bad information, you almost always want to be the one that mentions it. You know, we call it drawing the sting in law, in litigation. We call it drawing the sting, right? If there's bad information for your side, you want to be the one to mention it because you can choose when and how and exactly what way and how to massage it into the story, right? And how to put it into the narrative so it doesn't disrupt things, right? You can choose exactly when to say it, exactly how to say it, exactly where it is, right? You can control everything about it. You can control how it's presented. You can put a little bow around it so it doesn't sound so bad. And the other side, if they are the one that presents it first of all, they're going to make it as painful as possible. And second of all, the jury's going to hate you because they think you're hiding something. Right? So I could be wrong, but I don't think it would have been that big a deal if Johns Hopkins had mentioned this. Right? It's like, no, they could have said something along the lines of, no hospital's perfect. We've certainly had problems, like every hospital does from time to time. We have, 3 different accrediting agencies that review us. We have X amount of doctors and Y amount of procedures and Z amounts of surgeries. And things happen as they do in the real world. And we take those reports seriously, and we're always looking to mitigate and make our practices better, to bring a better quality of care to our patients that the people of Johns Hopkins expect, right? How hard would it be to come up with some version of that would be sellable? And then when the other side mentions this, be like, yeah, we know that. We told you. It's only because Johns Hopkins went so out farther away to say, no, nothing's wrong. Everyone loves us. No, there are no reports. Everyone loves us. That it seems so damning, right? And even if IJs are common, like this jury wouldn't particularly know that. I mean, it can all be managed, but it's they put themselves into an unforced error. They opened the door. They didn't have to. If they had just admitted everything, they wouldn't have opened the door. Right? If they had just said it, there'd be nothing to rebut. Right? You could cross them on it, but you wouldn't have rebuttal. The only reason there's rebuttal is because they didn't mention it. So this whole thing is a complete unforced error by Johns Hopkins. So I'm getting the sense that both sides do the unforced error thing. We're going to see another unforced error by Maya's attorneys later in this stream that really made me go insane. And fortunately, they managed to somehow salvage the unforced error, somehow. But we're going to watch it later because it made me lose my shit. Okay? But apparently both sides like the unforced errors. I don't know why. All right. So now we're going to skip ahead. We're going to skip ahead to jury instructions, and we're going to skip ahead to...
They have a moment, Your Honor.
You may.
Did I lose my place? Oh, that's not fair. I had pre-tagged all the times, but I didn't write them down. Damn it. I was so clever. I opened up on different tabs, so I'd have the times. And now... Damn it. I was so clever. But I didn't write down the exact times. Hold on. I have to find the moment. Give me a second. Talk amongst yourselves. What? I'm looking for the jury instruction, by the way, for the intentional infliction of emotional distress. So I have to figure out what time that is. I had it marked, and then it screwed me up. I didn't realize it wouldn't preserve my mark because I had it all marked up and nice to go. But I was going to go to the instruction for the intentional infliction of emotional distress. By the way, since I failed to mention it at the top of the stream, Johns Hopkins did have a minor win earlier today. Well, they had 2 minor wins, I suppose. They got 2 of the causes of action dismissed against them. So Johns Hopkins had some minor wins today. So Johns Hopkins got 2 directed verdicts in their favor. Johns Hopkins got, first of all, the negligent infliction of emotional distress claim dismissed, or directed verdict either way. Doesn't really matter. Okay, so the intentional infliction of emotional distress is still surviving, and we're going to hear that instruction in a bit. The negligent infliction of emotional distress was dismissed. And the reason for that is that it's a straight legal issue, as you'd expect. It's a straight legal issue. Negligent infliction of emotional distress requires physical injury. This is well established at law. Okay, this is well established at law. Negligent infliction of emotional distress requires physical injury. The judge had previously ruled that Maya's mom self-deletion could not be used as the injury for this negligent infliction of emotional distress. And we've talked a little bit about the legal reasons why that's true, right? It has to deal with causation, it has to deal with a whole bunch of issues. Okay. But they because also it's something they did to themselves, as opposed to the injury being caused by the infliction. So it's a straight legal issue. So they said that Maya's mother's self-harm could not be used as the injury. And then the judge ruled that there was no other injury that was caused by the negligent infliction of emotional distress, right? There might be other injuries that were caused to Maya or Maya's mother, but not as a result of the negligent infliction, right? The negligent infliction did not itself result in any damages, as opposed to something else. So the judge dismissed the negligent infliction of emotional distress because there was no evidence to support damages. And therefore it was lacking an essential element, and therefore it had to be dismissed as a matter of law. So there was that. The Johns Hopkins also won dismissal of the charge of negligent instruction, negligent teaching, right? As a separate cause of action unto itself. So one of the things that Maya was suing for was that the hospital was negligent in how they instructed their staff. Okay, and there was, what did I miss? Okay, apparently I missed something. Anyways, John Hopkins was, give me a second. Maya was suing for negligent instruction, the failure to adequately teach, adequately instruct their staff, as a standalone cause of action. And the judge ruled, I think quite appropriately, that didn't really make sense. Because, again, in order to have negligence, you have to have damages. It's one of the essential elements of negligence. You have to have damages. So you have to show how the failure to instruct resulted in damages. But the problem is that those damages are, in the end, inseverable from the medical malpractice cause of action, right? Because how do you separate out the damages that occurred from a failure to instruct versus the medical malpractice, right? The doctor did a malpractice on you. To what degree is that due to them doing the malpractice versus them failing to be sufficiently taught, right? And again, it doesn't matter that they weren't taught properly. Okay, that isn't the issue. The fact that they weren't taught properly has to itself result in damages. So if they weren't taught properly, but somehow just managed to get it right, or it didn't result in harm to you, then no harm, no foul, right? So if they weren't taught the right way to do it, and they did, even if they did it the wrong way, but it didn't result in any damage, somehow, despite the fact they did it the wrong way, despite all that, it still somehow didn't result in a problem, then no harm, no foul. No harm, no foul, right? So you have to show not only were they instructed improperly, but you have to show that that instruction itself resulted in actual damage, and you have to separate out that damage from the medical malpractice damage. So you have to separate out the fact the doctor was taught poorly that caused the injury versus the doctor performing poorly that caused the injury. And the judge kind of ultimately ruled in the end that it was just impossible. It was just impossible as a standalone cause of action. So you couldn't sever it out. You couldn't separate it out. So they can still talk about failure to train. They can still talk about failure to educate. That's all still relevant, but it's relevant as to medical malpractice. It's not relevant as to a cause of action to itself, right? It's not a standalone cause of action. And to the extent it is a standalone cause of action, it was duplicative because you literally couldn't sever it out. It was duplicative of another cause of action, and you can't get recovery twice. You can't get recovery for the same cause of action twice. You can only recover once for any particular thing. So because it couldn't be severed out, because it was duplicative, the cause of action was dismissed. So 2 minor wins for Johns Hopkins. Now, it doesn't really matter very much in the grand scheme, because Johns Hopkins is still going to have the problem of the medical malpractice, and they're still going to have the problems of the intentional infliction of emotional distress. So it's a little bit inconsequential, but of course lawyers fight every bit they can. They should. It's part of their job. So, Johns Hopkins was right. They were right. They were right on the law. The judge was right to dismiss it. They were correct. So, fair enough. They were correct. Not that it matters that much. Johns Hopkins is still going to have to write a check with many zeros on it, I think. But, we'll see. So that's where we're sitting on that. So just a little FYI, because I didn't mention it at the top. All right, so it's a little bit further than 608. A little bit further than 621. Okay, fourth claim is 630, and I'm looking for the fifth claim, so I'm getting closer. All right, 638 looks like we're close. Okay, here we go, 637. All right, I found it. Yay, we found it. All right, so what we're going to do is we're going to listen to the jury instruction for the intentional infliction of emotional distress, because I think it is the most legally complicated. It is the most factually complicated, and it's the one that's also arguably the big money damages, right? Because the death of the mother is the big money damages. So I think it's the most interesting, and it'll be interesting to listen to and see if they can do it. So we're going to listen to the jury instruction for that. Kurt is a legal black and white kind of guy. I do. He would do well to listen to us non-lawyer types to factor into his tanks. Well, I try to look at it to the law because I'm a legal educator. I try to give you legal education. That's what I do. So I think looking at this from a legal perspective is what I aim to provide. So I hope you enjoy the legal education. The law is justice can be zealous but not passionate. Justice is cold-blooded. Justice is not passionate. And so I tend to look at things in a very cold way, because that's what I'm supposed to do. It's how a judge is supposed to think. It's how you have to think in a very cold way. And I aim for that, and I think I'm very good at it. So I'll just continue doing that.
Children's Hospital caused Beata Kowalski to claim severe emotional distress, egregiously causing Beata Kowalski severe emotional distress. In this claim, the estate claims that the extreme and outrageous conduct of Johns Hopkins All Children's Hospital caused Beata Kowalski to suffer severe emotional distress prior to her death. Through this claim, the estate now seeks to recover for that harm. Johns Hopkins All Children's Hospital denies this claim. The estate must prove its claim by the greater weight of the evidence. I will now define some of the terms you will use in deciding.
So this is what we're on, right? Claim 5, survivor claim for intentional infliction of emotional distress for the state of Beata. So that's where we're at, right? This claim, this is basically, we're trying to essentially get to Beata's death. And we're trying to get to it through intentional infliction of emotional distress. So we got to try to make this vehicle work. So let's see if we can make this vehicle work for this. I'm dubious. I'm dubious we can make this vehicle work. I'm deeply dubious we can make this vehicle work. But let's listen to the instructions. Let's see if we can make it work.
This claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. Extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct.
Be careful with your language, Samantha's saying they tortured her. Be careful with your language. You know, that's charged language. If you don't stick to the facts, you're not going to come out with the right decision. And the right decision may not be the decision you want to do. Justice Scalia once said, and I don't think he was the first one to say it, but Justice Scalia once said that a judge that always rules the way they want to rule is not a very good judge. And there's been more than a few occasions on this channel, as longtime viewers of this channel can attest, where I've had to rule against my personal desires. So there have been more than a few times where I've said, no, I can't do this. I want to, but I can't do it. So like you got to pay attention. You know, if we're gonna play this game. You know, if we're gonna play the law game, we got to pay attention to the facts as they are. So, you know, let's try to keep our eye on the ball.
This be said, severe emotional distress, so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. In order to be regarded as a legal cause of severe emotional distress, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct must be a legal cause of severe emotional distress, even though the act of another or some other cause also contributes to the distress. The issue for you to decide on the estates, and that should read fifth claim. The issues for you to decide on the estate's fifth claim are: 1. Whether Johns Hopkins All Children's Hospital, through its agents and employees, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress. And if so,
right? So it's intent. It's the intent to cause that harm. They have to be trying to cause the harm. And remember, this is the intent towards Maya's mother, not towards Maya. It's during the time Maya's in the hospital. But it's not towards Maya. It's towards Maya's mother. The intent is towards Maya's mother for the harm. So we have to be looking at words or actions towards Maya's mother. That's the key. Reckless is where you know a bad thing is going to happen, but you don't know exactly what the thing is. Right? Reckless is wanton disregard. Reckless is driving your car really fast when you're drunk. Reckless is driving your car really fast on a wet road. Reckless is acting in such a foolhardy manner that something bad was going to happen. You may not know exactly what, but something, right? Reckless is careless, well, it's more than careless, really. It's wanton disregard. It is devil may care, laughing in the face of consequence. That's reckless.
Whether that extreme and outrageous conduct was a legal cause of severe emotional distress to Beata Kowalski.
The text messages, what text messages are you referring to? The text messages between the doctors don't count. Did Maya's mother see the text messages? Then they don't count. Remember, it's conduct towards Maya's mother. The text messages don't count. The text messages don't count. They're not towards Maya. Is Maya's mom in the text message exchange? Does she know about the messages? Did they tell her?
If the greater weight of an stress, and if so, 2, whether that extreme and outrageous conduct was a legal cause of severe emotional distress to Beata Kowalski.
One of the text messages said they were clearly expecting her to commit self-harm. Okay. Noted. All right. What do you want me to do with that?
If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the estate's claim, your verdict should be for the estate and against Johns Hopkins All Children's Hospital.
Hey, Runkle, thanks for dropping by.
If your verdict is for Johns Hopkins All Children's Hospital.
Sorry you're not feeling, by the way, Runkle. Runkle the Bailey, great streamer. And also, congratulations to Runkle the Bailey. For those of you who may not know, and some of you may not, Runkle the Bailey had a charity stream. Yesterday? I think it was yesterday. It's a little bit hard to tell at this point because time is a little bit, floaty. It might be the day before. Either way, he did a 24-hour charity stream, and he raised $107,000 for a child's hospital in Canada. $107,000, including perhaps most notably $450 raised by selling literally a rock. The rock went for $450. We appreciate everyone who contributed. It was awesome.
You will not consider the matter of damages. But if the greater weight of the evidence supports the estate's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows will fairly and adequately compensate the estate for the loss, injury, or damage occurring prior to the death of Beata Kowalski on January 8, 2017. If you find for the estate, you shall consider the following elements. A, any resulting pain and suffering, mental anguish experienced by Beata. Let me read again. If you find for the estate, you shall consider the following elements. Any resulting pain and suffering or mental anguish experienced by Beata Kowalski prior to her death on January 7, 2017. There is no exact standard for measuring such damage. The amount should be fair and just in the light of the evidence. Now, members of the jury, I noticed that we, in one case, said that Beata Kowalski died on January 7th and another time on January 8th. I think the evidence was it was in that time frame. I apologize, I was not consistent, but the intent here is the damages before her death, okay? Whether it's on January 7th, the evening of the January 7th, or the morning of the 8th. Moving on to Claim 6.
All right, so there's Claim 5, right, in its totality. And as I've said, it's a bit of a hard sell because you have problems all out the place. You have problems about specifically what they did or said to let me just highlight the problems. Okay? And some of these problems are problems that are more from an appellate posture because you know for an absolute certainty, of course, if Maya Kowalski wins, which I think is quite likely to be honest. I think the jury is likely to rule for her. And I think they're likely to win a big award. So we're talking more about this from an appellate posture, from a legal posture, than from a factual posture, right? But you know this is going to the Florida Supreme Court, right? We all know this is going to the Florida Supreme Court, right? All right. So when it eventually gets to the Florida Supreme Court one of these days, some of the problems that they will have to decide are going to be some of the things that we're going to talk about a little bit. So first of all, you have the problems about what exactly they did to Maya's mother. That was extreme and outrageous, and also it's, of course, as always, circumstance dependent. So one of the problems is like, what did they do to her? And I don't think it can be enough to merely say, like, we think you're doing Munchausen's by proxy. I don't think that's enough because they're in a hospital. It's a medical diagnosis. It's a purpose for discussion, right? It's like we don't feel that she's safe at your home with you because we think this is what you're doing to. So a lot of these statements are arguably privileged or quasi-privileged because they're in this particular context of medical diagnosis to Maya, arguably, and let's assume for the purposes of the discussion that they really thought that was true, um, that they were trying to help Maya, at least initially, and so the things they were saying they weren't said with an intent to be cruel, right? They weren't said with intent to be cruel. They were said because they believed them to be true, right? And that's a huge difference if they believe them to be true, right? Intentional infliction of emotional distress is all about words or statements that are societally unacceptable because they are something no reasonable person should be expected to bear because they are so outrageous in their character, right? The classic example of intentional infliction of emotional distress, like the one I always learned about in the law books when I was studying it way back when, right? And the classic example is you knowingly go up to a mother and you tell her, knowing that her child is in fact fine, so you know this, you go up to her and you tell her her child is dead. All right? This is the kind of thing we're talking about. It's not that you're mistaken. It's not that you're confused. It's not that whatever. It's that you were doing it purposefully for the purpose of just being a cruel bastard. Okay? This is the kind of thing we're looking about. This is the kind of thing we're talking about. We purposefully are doing it directly to you because we want to be a cruel bastard. Right? This is Mean Girls on absolute steroids. This is the kind of thing we're trying to deal with. One of the things we have to deal with separately when we're trying to deal with this legally is we have to separate out the words which might themselves be cruel in another context, right? We think you're abusing your child might be words that would be considered to be cruel in a different context, but are they cruel in this specific context? Because if they genuinely believe that, and there's no reason to believe they didn't when they said it, right? They might have doubled and tripled down, but there's no reason to believe they didn't really believe it when they said it, I don't think. But maybe you guys disagree with that. Maybe you think they never really believed it. But if they really genuinely believed that, and they were doing it for the purposes of medical diagnosis, and we're like, we're concerned that the mom is the problem, so we need to keep mom away because she's the issue, right? It's like, is that intentional infliction of emotional distress is challenging. And then, of course, we have a huge causation problem because it has to be, that the distress was causing a problem of a psychological nature that's somewhat distinct from her self-harm because her self-harm is arguably a voluntary act, at which point we have a problem because we have a causation problem. So there is a lot of issues. And even if they could, in some sense, predict that the self-harm was coming, and incidentally, I know the text message you're talking about, and I'm not quite sure that's what the text message said, but let's let that go by. Even if they could, in some sense, predict it, it doesn't necessarily mean that they're responsible for it, right? I might be able to predict that you're going to do, if you get in your car and you're like, I'm going to drive very fast, off this cliff. I'm like, this is probably going to kill you. if I'm right, that doesn't necessarily mean I did anything wrong. So the mere fact that I'm able, if I see you about to do a stupid thing, right? If you give me your beer, you say, hold my beer while you watch this, and I'm like, this guy's about to get hurt. This is not going to go well for him. The fact that I'm right in my prediction doesn't mean I have liability, right? So the mere fact that I can foresee your very imminent harm coming your direction is not necessarily my problem. So, hey, watch this. Hold my beer. It's like, okay, well, he's going to die. So the mere fact that they can predict it isn't necessarily intentional infliction. So, okay. Let's listen to the next charge as well, because it's also relevant to this.
Claim for your consideration in this case is a claim brought by the estate of Beata Kowalski. The estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide.
This is the real challenge.
Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, the fifth claim, that the estate did not prove its claim. Actually, can I see the attorneys for a second on this?
Yeah, so this is the big one, right? So is it a legal cause of her not being on this earth anymore? That's challenging.
I'm going to restart at the beginning of page 46 because I don't exactly know where I was. The sixth claim for your consideration in this case is a claim brought by the estate of Beata Kowalski. The estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously during the time that Maya Kowalski was a patient at the hospital, and that this conduct is a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital denies this claim. If you decide on the verdict form for the survivor claim, which is the fifth claim, that the estate did not prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide in favor of Johns Hopkins All Children's Hospital on this sixth claim.
So if they win on 5, they win on 6. So they can only get to 6 if they get to 5. So without the underlying emotional damage, they can't get to 6. So if Johns Hopkins wins on 5, they win by 6. They win on 6 by default. That's what that says.
However, if you decide on the verdict form for the survivor claim, which is the fifth claim, and that the estate did prove its claim that Johns Hopkins All Children's Hospital acted extremely and outrageously, causing Beata Kowalski severe emotional distress, then you must also decide the issues in this sixth claim. The estate must prove its claims by the greater weight of the evidence. I will now define some of the terms you will use in deciding this claim. Greater weight of the evidence means the more persuasive and convincing force and effect of the entire evidence in the case. Extreme and outrageous conduct is behavior which, under the circumstances, goes beyond all possible bounds of decency and is regarded as shocking, atrocious, and utterly intolerable in a civilized community. Emotional distress is severe when it is of such intensity or duration that no ordinary person should be expected to endure it. I apologize. Was I at the greater weight instruction?
You're at the issue for you to decide.
Okay, I apologize, members of the jury. The issue for you to decide on the estate's wrongful death claim are: 1, whether Johns Hopkins All Children's Hospital, through its employees or agents, engaged in extreme and outrageous conduct during the time that Maya Kowalski was a patient at the hospital, and acted with the intent either to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, and, if so, whether that extreme and outrageous conduct was a legal cause of Beata Kowalski's death by suicide. Johns Hopkins All Children's Hospital did not need to specifically intend for the conduct of its agents and employees to cause Beata Kowalski to die by suicide. However, the agents and employees of Johns Hopkins All Children's Hospital needed to engage in extreme and outrageous conduct with the intent to cause Beata Kowalski severe emotional distress, or with reckless disregard of the high probability of causing Beata Kowalski severe emotional distress, sufficient to be a legal cause of her death by suicide. To be a legal cause of Beata Kowalski's death by suicide,
Pay attention to this.
the extreme and outrageous conduct must either: 1, create in Beata Kowalski an uncontrollable impulse to commit suicide, or 2, be a substantial factor in bringing about the suicide.
Yeah, I don't know about that.
Uncontrollable impulse means a mental state that prevented Beata Kowalski from appreciating the nature of the act of suicide or controlling her conduct. In order to be regarded as a legal cause of death by suicide, extreme and outrageous conduct need not be the only cause. Extreme and outrageous conduct may be a legal cause of severe emotional distress, even though it operates in combination with the act of another or some other cause, if the extreme and outrageous conduct contributes substantially to producing such severe emotional distress. If the greater weight of the evidence does not support the estate's claim, your verdict should be for Johns Hopkins All Children's Hospital. However, if the greater weight of the evidence supports the estate's claim, then your verdict should be for the estate and against Johns Hopkins All Children's Hospital.
That's so tough legally. Like, irresistible impulse is like basically insanity. And the second one, substantial factor that caused the suicide. Yeah, I'm not sure 100% what that means in this context, right? Because you're talking about an emotional harm, right? You're not talking about physical harm, right? If you're talking about someone physically doing something to somebody and say, was this a substantial cause of their death? This I understand, right? Because you're like, okay, well, this is like George Floyd kind of with Chauvin, right? In some ways, it's like, are you a substantial cause? Like, yeah. So you can very much reach the conclusion, if you want, that the drugs killed Chauvin and also, or that drugs killed Floyd, and also Chauvin killed Floyd, because those are not mutually exclusive concepts, right? Because they both are substantial causes. And either one could be sufficient, incidentally, and it'd still be a substantial cause. So you can do that. But here, you're dealing with an emotional thing, right? You're dealing with emotional things. So it's like, how do you demonstrate what does it even mean to be a substantial cause at that point? What does it even mean to be a substantial cause in this context? Right? What? I don't know. I don't know what this means, and I don't know how to separate this out. And it seems legally the problem is the problem, for those of you wondering why I'm struggling with this so much, by the way, is I'm trying to deal with this in a global way, right? I'm trying to think about this in a global way. In case you're wondering why I'm struggling with this so much, right? I'm trying to, in my mind, figure out what a rule would be that would apply to this situation, and also how that rule would apply to other situations. Because it's one of the things you have to think about in law. You have to think about, you can't, there's a common saying that hard cases make bad law. And this is one of the reasons why hard cases make bad law. Do I want to am I upset that Maya's mother's dead? Of course I'm upset. Of course I'm upset. But I got to think bigger than that, right? I can't just take the impulse of a bad thing has happened and use my empathy and just be like, give her all the money. A lot of you guys have that impulse. I have that impulse too. I understand the impulse, right? I get it. It's very human. Maybe you don't believe I have the impulse because I'm so cold or calculated or doubtful about it, but I'm trying to very deliberately look at this in a more universal way. And so I'm trying to figure out what the rule is here. And so it's like, okay, if this is the rule, like if this jury instruction is the rule, you can sort of imagine without too much thought, I think, you can imagine how this rule would apply in a much wider swath of cases than the immediate situation, right? Does this rule apply to anyone who bullies another person and that person winds up harming themselves or someone else, right? Maybe they don't even harm themselves. Maybe they harm someone else, right? So can I sue them? Let's suppose because the irresistible impulse, right? It's like, okay, they were driven to the action of suicide. What if they're driven to the action of violence, right? Can I sue somebody, for example, for being a bully, and it's a substantial contributing factor to their emotional state, which resulted not in depression, but resulted in anger and caused them to lash out and then hit someone else and blah, 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 blah. It's like, what do we think about this? Be Kind Tiger says, what will the jury think? We are way past what the jury will think. We are way past what the jury will think when we're asking this question. You are asking entirely the wrong question when you ask, what will the jury think? You're asking way the wrong question when you say what the jury will think. The right question you need to be asking is, what will the Florida Supreme Court think? That's the right question. We are way past what the jury will think because we're dealing with issues of law. The jury gets to decide? No, they really don't. These are issues of law. These are issues of law. Juries get to decide facts. Courts get to decide law. And this is legally problematic. This isn't factually problematic. This is legally problematic, right? My questions are legal in their nature. I'm not asking factual questions. I'm asking legal questions. I'm asking questions like, what is the rule? That's a legal question. How does that rule apply to other cases? That's a legal question. Can I use that rule in a case of a bully? That's a legal question. Those aren't factual questions. That's legal questions. My questions are, what are the rule? How does it apply? How do we think about it? Right? So, we are way past what the jury will think. My prediction is the jury is going to find for Maya. My prediction is they're going to rule for Maya's favor for cause 5 and 6. My prediction is they're going to give Maya a very substantial reward. So if your question to me is, what's the jury going to do? The jury is going to find for Maya. But that's in no sense the end of this rodeo. That's in no sense the end of this rodeo. The question is, what's the Florida Supreme Court going to do with this 4 years from now? How are they going to think about it? How are they going to think about this instruction? You know? We are way past what the jury is going to think. So, yeah. The jury trials for naught? Maybe. At least to this aspect, it might well be. Now, that isn't true for all causes of action. So it won't be completely for naught, but it might be not for cause of action 6. So that's quite possible, and I think the jury forum asks the separate questions. So it's not totally for naught, but it might be partially for naught. Yeah, if that's what appeal courts are for. Do you not understand what appeal courts are for? They're for like questions of law. That's what they do. That's what they do. They say, yeah, the trial court made a mistake. This is not good. This is good. That's what they do. Yeah, so it may very well be that cause 6 was doomed the moment it started. It may very well be 4 years from now. The Florida Supreme Court says, no, that $100 million for cause 6 disappears. What about social media influenced unalive recent cases? I'm not aware of all the cases you're referring to. Some of those cases are criminal, and the criminal law is different than the civil law, because some of that's based on statute. And also because the legislature has, at least to some degree, although not completely, passed laws dealing with things like harassment and cyber harassment. And so it's a little bit easier in some cases to paint a criminal picture. This is the first civil case ever. This is the first civil case ever that's gone to a jury on this question. It's never happened before, ever. This court is trying to invent new law right before your eyes, which is fine. That's how the common law works. That's the history of common law. Courts just invent new causes of action. So, like, you know, it may very well be, 50 years from now that this is a new cause of action on the books. But it's not now. A court is literally trying to invent a brand new cause of action literally in front of you. They're just creating it from nothing. Perhaps with some inspiration from some of the criminal cases, but they're just creating it. They're creating a brand new cause of action right in front of you. So, yeah, that's where we're sitting.
If your verdict is for Johns Hopkins All Children's Hospital, you will not consider the matter of damages. But if the greater weight of the evidence supports the estate's claim, you should determine and write on the verdict form in dollars the total amount of loss, injury, or damage which the greater weight of the evidence shows the estate of Beata Kowalski and her survivors sustained as a result of her injury and death, including any damages that the estate...
Like racketeering a little bit, but then again, someone wrote RICO. So, yeah, they invented RICO. The Nixon signed RICO. Yeah, like racketeering, yeah, but again, that was statutory. And then Georgia invented a version of RICO, but that's statutory. That's the legislature, right? So racketeering is an example of the legislature creating laws. That's normally how laws get created, right? The legislature passes law. The legislature passed RICO. This is a court trying to invent a cause of action. This is a court trying to create a brand new cause of action. It's wild. It's not exactly unique, by the way. Common law is littered with this. The history of common law, although you haven't seen it, you don't see it as much now. You used to see it a lot more back when there were fewer causes of action. But the common law is littered with courts just inventing causes of action. We read one time on stream, I think we've read it 2 or 3 times on stream, We read the very first assault case ever. We can actually point to it, which I think is just wicked cool, by the way. I think that's just super cool. You can actually read the very first assault case that ever occurred. There's a record of it. A judge just invented a cause of action called assault. A guy in England or Wales, we're not sure which, a guy in England or Wales goes to a tavern at night. It's late. The tavern is closed. The people who run the tavern live in the tavern because, it's the 14th century. Okay? They live in the tavern. It's their home. This guy comes late at night, early in the morning, starts beating on their door, beating on their boarded up windows with an axe. The wife pops her head out to see who the hell is, trying to beat her door down. And this guy with his axe in hand takes a swipe at her with his axe. He misses. She sues. Well, it's not battery because he didn't hit her. So the court just invented a brand new cause of action. We called it assault. It was the very first assault case ever. It was a drunken guy trying to get a drink at 2 o'clock in the morning. What are the odds?
And the survivors are reasonably certain to occur or experience in the future. Elements of damage for the estate. In determining the damages recoverable on behalf of the estate of Beata Kowalski, you shall consider the following elements. The estate's loss of net accumulations. Net accumulations is the part of Beata Kowalski's net income from salary after taxes, including pension benefits, which Beata Kowalski, after paying her personal expenses and monies for the support of her survivors, would have left as part of her estate if she had lived her normal life expectancy. Elements of damage for surviving spouse and children. In determining any damages to be awarded the estate for the benefit of Beata Kowalski's surviving spouse and children, you shall consider certain additional elements of damage for which there is no exact standard for fixing the compensation to be awarded. Any such award should be fair and just in the light of the evidence regarding the following elements. A. Damages of surviving spouse. Jack Kowalski's loss of Beata Kowalski's companionship and protection, and his mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of the losses, you may consider the life expectancy of Jack Kowalski together with the other evidence in the case. B. Damages by surviving children. The loss by Kyle Kowalski and Maya Kowalski of parental companionship, instruction, and guidance, and their mental pain and suffering as a result of Beata Kowalski's death. In determining the duration of those losses, you may consider the life expectancy of each of the surviving children together with other evidence in the case. C. Loss, support, and services. The survivors, Jack Kowalski, Maya Kowalski, and Kyle Kowalski's loss by reason of Beata Kowalski's injury and death of Beata Kowalski's support and services from the date of injury to the date of death. In determining the duration of any future loss, you may consider the joint life expectancy of the survivors and Beata Kowalski in the period of minority ending at age 25 of Maya Kowalski and Kyle Kowalski. And D. Medical and funeral expenses. The medical and funeral expenses resulting from Beata Kowalski's death paid by Jack Kowalski. In evaluating past and future loss of support and services, you shall consider the survivor's relationship to Beata Kowalski, the amount of Beata Kowalski's probable net income available for distribution to the survivor, and the replacement value of Beata Kowalski's services to the survivors. Support includes contributions in kind as well as sums of money. Services means tasks regularly performed by Beata Kowalski for a survivor that will be a necessary expense to the survivor because of Beata Kowalski's death. Any damages that you find were sustained by Beata Kowalski's estate and by Jack Kowalski, Maya Kowalski, and Kyle Kowalski shall be separately stated in your verdict. Mortality tables. In determining how long Beata Kowalski would have lived had she lived out her normal life, you may consider her life expectancy at the time of her death. The mortality tables received in evidence may be considered in determining how long she may have been expected to live. Mortality tables are not binding on you, but may be considered together with other evidence in the case bearing on her health, age, and physical condition before her death in determining the probable length of her life. In determining the duration of any future loss sustained by Jack Kowalski, Maya Kowalski, and Kyle Kowalski by reason of the death of Beata Kowalski, you may consider the joint life expectancy of Jack Kowalski, Maya Kowalski, and Kyle Kowalski, and Beata Kowalski. The joint life expectancy is that period of time when both the decedent and a survivor would have remained alive. The mortality tables received in evidence may be considered together with the other evidence in the case in determining how long each may have been expected to live. Any amount of damages which you allow for the estate's loss of net accumulations should be reduced to its present money value, and only the present money value of these future economic damages should be included in your verdict. The present money value of future economic damages is the sum of money needed now, which, together with what that sum will earn in the future, will compensate for these losses as they are actually experienced in future years. The seventh claim for your consideration in this case.
So that will take us to the end of that stuff. So I just wanted to read those two jury instructions because they're the most critical. Dealing with the death of Maya's mother. Those are the really big ones, right? The other stuff is, I think, is easy enough and is sellable enough. False imprisonment, battery, medical malpractice, some of the other stuff that's, is really, I think, self-evident. But to my mind, fairly low dollar amounts. This is like the big ticket item. For the battery, for the false imprisonment, probably I'd think an award of, maybe $3 million. For the battery, maybe about the same, $3 million. The med mal is going to be fairly expensive. That's going to rake up some money. That's a lot of stuff, and some of the stuff they did there. So you're talking probably into the tens of millions. But the death of Maya's mother is probably the big one. That's the one where you're talking some really big numbers. You're talking, $60, $70 million for that. So that's kind of what's going on, what I think. Someone asked about sanctions. I don't think the sanction thing is going to be a thing. I appreciate everyone who sent me a copy of the sanctions motion. I'm not going to cover it, mostly because I don't expect anything to come from it. If the judge has not given sanctions at this point, he's not going to give any meaningful sanctions. Any sanctions he's going to give are going to be, in the grand scheme, fairly de minimis. He's not going to strike someone's pleading at this point. The case is over, so he's not going to give someone more time. He's not going to prevent a witness from being called. He can't at this point anyway, because they've already been called. So, what's he going to do? Right? He's not going to strike he's not going to be like, oh yeah, I'm so pissed, I'm going to strike Johns Hopkins' answer, and now that there's no answer, that means that there's a default. And so Maya just wins by default because there's no answer. Yay, let's just go straight to damages. He's not going to do that. So I'm not going to cover the sanctions motion because honestly, I expect nothing to come from it. Maybe he'll find the party something, but what's he going to do? Find him a couple $1,000s? It's chump change. It's chump change. So I don't expect anything to come from it, so we're not going to cover it because I don't care. All right, but what we are going to cover is Maya's attorneys being really, really dumb, just all the dumb, incredibly dumb, on juror number 1. So we're going to skip ahead to wherever they have this discussion, if I can find it. This is going to take a second again because I lost my place. And we're going to discuss the stupidity that was juror number 1 and Maya's attorneys just being incredibly idiotic. And me just losing, my last bit of patience. All right, hold on. All right, so this is for the dismissal of the juror, all right? So I thought this motion was incredibly stupid by Johns Hopkins. Johns Hopkins moved to dismiss a juror because they didn't like the questions the juror was asking, okay? It was incredibly stupid, and I mocked it on stream, and I stand pretty much by everything I ever said. Yeah, 1348, that's it. IDS at UX, that's right. IDS at UX, 1348. You got it. I said 14th century, so not too bad. First assault case ever. IDS at UX. Yeah. I is the guy's name. Yeah. Yeah. This is what we have left all these years later. This is what we have left, which is kind of funny, right? I is the guy's name. Day S. S is his location. So it's I of S at UX is wife. Et ux means and his wife. That's what et ux means. So if you want to translate that into modern English. So it's I of S and his wife. Versus, yeah, so wherever S is. So whoever I is and wherever S is, IDS et ux. I of S and his wife. Yeah, great case. And of course, because it's the 14th century, she doesn't have the right to sue in her own name. Which is why, even though she's the one being assaulted, it's not ux versus, right? Because it's the 14th century. So it's the man suing because his wife can't sue in her own name because it's the 14th century. I have S and his wife. Yeah, good times. But she won. She won. Anyways, back to juror number 1. Now we've had our walk through history and the Assize, where we were doing a riding circuit in England. Some guy in 1348 or 1349 at the Assize, which means we're riding circuit, riding around, hearing people's cases, wrote the first assault case ever. But that was 1348. Coming to 2023, a slightly later year, we're now dealing with the issue of juror number 1. Okay, juror number 1. Juror number 1, they want to dismiss him because he has asked questions that they don't like, okay? So we're going to watch Maya's attorney's response because their response was incoherent. It was incoherent, okay? So the attorney for Johns Hopkins has just finished talking for a little while. They said, the attorneys, this is the first time in 40 years I've ever done this. I've never seen a juror like this. All right, so let's listen to Maya's attorney's response, which is just full of dumb.
I will, Judge. It's interesting, the perspective, because I went back and looked at my notes from the first 2 weeks, and I had a big question mark next to Juror 1 as to whether he was dead set against our position based on the questions that he asked. He didn't say he had the same ethnic background. He said Nordic and a certain blunt way, I believe was his question. So he was not trying to identify himself because she's from Poland, and I think he's talking about Sweden. And the breath of fresh air, he just said, period. He wasn't addressing that, and we don't know from that. What we're doing here is trying to go back and do another voir dire or redo voir dire. This this juror, like the court said, is probing every bit of this evidence and every one of these witnesses. And thank goodness there are jurors like that out there. So just because he has asked these type of questions does not disqualify him. If anything, he seems like a pretty contemplative juror, as do all of ours. So that having been said, we don't want an appellate issue, any more of the appellate issues than the...
Well, let me just stop you right there.
Go ahead.
Ms. Crowells is suggesting that juror number 1 status be changed from on the jury to being an alternate. So effectively not disqualify him, just shuffle the chairs. At the end of the day, do you agree doing that because you're concerned about it for whatever reason? Do you agree to do that or not? Because if you're going to agree to do that, we'll walk a certain path. If you're not agreeing to do that, we'll walk a different path.
All right. So first of all, I'd like to take note that the judge is like, okay, what do you want? Which tells you right away that we're not dealing with great. Because the judge is like, I don't want to worry about the appellate issues. The judge is like, just tell me what you want. What do you want? It's like, first of all, this reshuffling idea makes no sense to me at all. I don't understand this reshuffling idea at all. Let's take this juror, who's one of the 12 jurors right now, or one of the 6 jurors, I should say, rather, because it's a juror of 6 with 6 alternates. Let's take one of those jurors and make him an alternate instead, because he's so biased. He's so incredibly biased. Okay, that doesn't make any sense. That doesn't make any sense, right? Because keeping him on as an alternate implies that he's usable, right? That's why the alternates are there, right? It's not like, I'm not sure what scenario this would be, but it's not like, he can't be a juror right now, but maybe he can be an alternate juror because of some scenario, right? What's going to change? Nothing's going to change, right? Nothing's going to change. So making him an alternate makes no sense. So, if their position is, let's make him an alternate, I just would throw that right in their face. I'm like, I'd literally go say, Johns Hopkins doesn't even believe in what they're saying. Johns Hopkins' view is he should be an alternate, which implies the possibility that he could be a juror, right? I don't know what scenario this is where 4 members of the jury are going to fall dead, but, it's possible. That's why we have them, right? So Johns Hopkins is opening the possibility that he could still be on the jury for some reason. And so, that doesn't make any sense. And then his position is so muddled, the judge doesn't even know what it is. Well, I'm not worried about appeal. The judge is like, just tell me, what do you want? Do you agree or do you disagree? All right, counselor, can you get this one right? Do you agree or do you disagree? Do you agree with this plan or do you disagree with this plan? Pick a side. Can you get the answer right? Let's find out.
Do you need a moment with Mr. Elliott and your team to decide that? Because when it's all said and done, if you're in agreement with Ms. Crowells on changing his chair from being on the jury to an alternate.
Well, my one question, I want to confirm who takes his place, obviously, which I think is juror number 5.
Whoever was the next.
My notes have.
We're not looking to shuffle the alternates, so whoever is the.
That's what I'm trying to figure out.
My notes have, and Madam Clerk, tell me if I'm wrong, that our jurors are jurors 1, 19. Sorry, our jurors are 1, 17, 19, 93, 97, and 98. The first alternate is juror number 106, the retired electrician.
Yes.
Yes, Your Honor.
That's our understanding as well, Judge.
So that's the first alternate. Do you all need 5 minutes?
Yes, Judge. I mean, we realize what we're trading out, I guess. And we understand the position of the defense is they just want to trade spots.
We just want to, well, it's not unusual in a trial to sometimes make somebody that was a juror an alternate if they fell asleep during trial, if they had issues. So that's our position.
I'm just wondering if there's an agreement obviating a ruling, or is
The judge is still trying to get to, what do you want? The judge is still trying to get to, what do you want? He can't get it. He can't get it. Do you agree or do you not agree? Do you want it or do you not want it?
a need for a ruling? And I just 5 minutes. Let's keep this to 5 minutes, because
Less than that, I just want to get
do you want me to just sit here and?
Yes, Judge. Let's just.
If you need to call Mr. Elegant, you can step outside and call him.
I think I just need to talk to him.
I'll just sit here and look pretty.
So now he's going to have a phone a friend moment to figure out what his position on this issue is. This burning question: do you agree or do you disagree? Do you want the juror to be substituted or don't you want the juror to be substituted? I couldn't help remember reading your motion where you spent quite a few words saying how stupid it is, and now you're not sure what you want. And it gets worse. Somehow it does get worse. It does get worse. The judge enjoying his sippy cup. I hope he has something good in his sippy cup because he needs it. I'm telling you what. Skip ahead a little bit. Skip, skip, skip. Skip, 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 skip. Skip some more.
I think I better stay with number one. I don't
So
think
you
we
were
have an
opposing the.
yeah, I think I need to oppose that.
Okay. We disagree. We disagree. I mean, you did spend all that time in your written motion saying how you disagree, and now you've had your caucus, and you've had your time to talk about it, and you've said, okay, we still disagree. We got the answer. We disagree. Right?
Very mixed feelings, but
Wait,
first,
what do you mean you have mixed feelings? Wait, what do you mean? What do you mean? What?
I think it's the right thing to do to keep him on there under the law and our system of choosing jurors.
Counsel, do you know where you are right now? Do you think the court can order a cognitive test in the middle of a hearing? Do you know where you are? Okay.
I don't see anything in his questions. I see him probing things deeply. And I think he, like I said, when we started out, I wasn't sure which side he's on, and I'm still not sure based on some of his questions.
Well,
I mean,
I think the point should be he shouldn't be on anybody's side at this point, Judge. That's the point.
They all form opinions at some point and through it.
See, that's the right answer, right? They all form opinions. Like, to think the jury wouldn't have any thoughts or be leaning one way or another at this point of the trial is ridiculous. Like, they shouldn't be on anyone's side. That's ridiculous. It's absurd. It's absurd. I scoff at you, ma'am. It's like I never wanted to be an attorney in a courtroom more than I was in this room. Because I just want to make fun of her and just ridicule her in open court. I was like, I need pro hoc vice. I was on my stream being like, put me in, coach, put me in. I'll do it. I'll argue the motion. Of course they have thoughts, man.
all cheering for one side or the other, and then they switch sides depending on the evidence. That's the nature of jury trials.
So So I need your final answer, Mr. Anderson, so we can get this thing going.
You're a lot of help.
Someone has to make.
The judge still not sure what you want because you said, I'll go with option one, and then you immediately said, well, I have mixed feelings about it. It's a complicated matter. It's like, okay, can we just please get to what do you want? Just tell me what do you want. I thought I had the answer, but now you're faffing around again. What is the answer? Just tell me what you want. How hard is this? Apparently very hard.
A decision for the plaintiffs. So you are there. If not, I'll call Miss Lawrence. You can give me the final answer.
Sounds good.
Call Miss Lawrence. Please, for the love of God. Call the newbie. I bet she knows the answer. Miss Lawrence is the brand new attorney, by the way. She's been a member of the bar for about a week or something. Okay, I bet she knows the answer to this question. Call Miss Lawrence. Maybe she can answer the question.
Well, where did you?
Put him on the spot.
You'd like to sub in Ms. Lawrence as juror number one.
We're not doing that, Mr. Whitney.
Apparently we're having another caucus now.
No, I changed my mind. I'll go with number 5.
So we agree. We agree. We did disagree, but now we agree. We agree. I've changed my mind. I'm okay with substituting out the juror. So I spent all that time on the written word saying we don't agree. Then I went outside and had a caucus about it for a while. We don't agree. And now I agree. Now I agree. Substituting the juror sounds great. I would like to substitute the juror. That sounds great. What? This is the first time I lost my shit. It wasn't, well, I'm not even sure that's true. It was a time I lost my shit, but it was not the last. There is more to come.
So I'll agree with you.
Ms. Lawrence, is this your final answer?
It's not number 5, it's 106.
Yeah, 106.
Oh, hang on then.
It's the one he announced, the electrician.
I'm sorry, 106, prospective 106. And
He's counting 1, 2, 3, 4, 5.
Yeah, yes.
That's
really
what he
sitting.
meant.
Okay.
Yeah.
It all depends on how you count.
All right, so are we concluded?
So we're good? We're good? So like Johns Hopkins over here is like, so we're good? Wow.
Ms. Lawrence, is that your final answer?
Are you sure? Are you really sure?
Yeah,
Okay.
I
Did you
think
say
I'm
apparently?
Yeah,
Hold on.
Ms. Lawrence, is that your final answer?
I think she might say apparently.
Yeah,
I'm can't tell, but I think she might say apparently.
I think I'm going to go with that.
Okay, so what we're going to do with the agreement of the parties, and this is the agreement of the parties, is juror number 106 will move into the status of being on the jury, and juror number 1 will move into the status of being an alternate.
Which alternate? Is he just going to swap with?
Is it going to matter after tomorrow?
Probably not, but
If someone has another medical emergency, we'll address it then, but
Yeah.
let's just pray no one has another medical emergency. How about that?
I hear you.
Let's
you know
not
what,
go about,
You know who I didn't check with through this whole thing? My client.
well,
I'm sorry. I'm sorry. What did you say? I'm sorry. Could you repeat that for me?
You know who I didn't check with through this whole thing? My client.
Well,
You know who I didn't check with through this whole thing? My client.
well, that would be important.
Check with through this whole thing? My client.
Well, that would be
Who I didn't check with through this whole thing? My client.
well, that would
You know who I didn't check with through this whole thing? My client.
well.
He didn't check with his client. He didn't check with his client. So there's that. Your client might have some input on this issue. You might want to at least, talk to them about it and let them know what's going on. Maybe. So, let's maybe check with the client. What do they have to add to the picture?
Well, that would be important.
Okay.
Well, let's let Mr. Anderson talk to Mr. Kowalski.
Okay. All right, then can we move to exhibits, Judge, unless you
Well,
have...
let's give Mr. Altenburn another moment.
Yeah, I'm waiting.
Going just that well,
Judge,
people.
Mr. Altler and I weren't able to talk, but I did send him a text.
I'm going to go with my client. I have to switch positions because my client feels.
What? We're switching again, people. Listen for that audible what?
I did send him a text.
I'm going to go with my client. I have to switch positions because my client.
We're still we're still on the question we started with, people. We're still on the question we started with. What do you want? What do you want? We're still on the question, what do you want? I object. I object. I don't object. I object. Please rewind jazz hands. You get a little jazz hands action you want to see again?
Send him a text.
All right.
Judge, Mr. Altler and I weren't able to talk, but I did send him a text.
I'm going to go with my client. I have to switch positions because my client feels more comfortable with juror number one. So I'm going to switch positions based on my client's input.
Yeah, it's going just that well. Rubio 4999 says Anderson has jury consultants who are making the calls. Great coverage, Kurt. Thank you very much, Rubio. That's very, very kind of you. Thank you for your contribution. Twisted Tragedy. Yeah, you say that they have jury consultants making the calls, but well, they seem to be confused. So they don't know what they want. They're confused. The client has thoughts, though. They think the jury should stay. Okay, it's going just like well. Okay, let's try again.
181 packet. Okay, so your final answer, and just so I'm clear, the plaintiffs are objecting to
This is the longest I've ever heard should take to answer the question, okay, what do you want? Do you agree or do you disagree? This is the longest I've ever heard it take. And we're on our third iteration of, is this your final answer? Which apparently it wasn't the first two times. But yeah, so we're still on what do you want? This judge has the patience of a saint. I tell you what, man, I probably would have given up long ago. This judge has the patience of a saint.
To the switch and wants, if I were to deny the change, your client wants the appellate issue.
To such as it is, I don't think there's much of one, but
Okay. So the final answer is you're objecting.
I'm objecting.
Okay. Anything further?
Oh my God, we finally got the answer. Because even the last time, did you hear it? Whereas like before, it's like we couldn't quite get a straight answer out of him. It's like,
Crowell. So
I don't think there's much of one.
if I were to deny the change, your client wants the appellate issue.
listen to this answer.
To such as it is, I don't think there's much of one, but
Okay.
He can't just say yes. He can't just say yes. We want the issue. Well, such as it is, I don't think it's much an issue. Just tell me what you want. Just tell me what do you want. Just tell me what do you want. Do you want me to have the juror? Or do you not want to have the juror? Yeah. Ruby, I believe you they have jury consultants. Apparently they're really conflicted, though, at the moment. So I don't know what's going on. Because we're spending so much time with, do you want them or do you not want them? How long does it take to get an answer, man? And still like, oh no, appellate issue.
So the final answer is you're objecting.
I'm objecting.
Okay. Anything further, Ms. Crowells?
Judge, I think we've laid out the bias that we believe this jury has shown. I think that the appropriate ruling for the court is to grant the motion. I think under the case law it's warranted. No, I have nothing further.
Court has before it the motion to disqualify juror number 1 for a question of bias. This is a very peculiar type of motion, and since normally when we see question of juror misconduct, it's they've violated some sort of instruction of the court, like don't go to the accident scene, and they go to the accident scene, or something along those lines. The court has given instructions which the defense says that this juror has violated. For instance, instruction 202.2, you must avoid forming any final opinions. Keep an open mind. Actually, keep open mind is from 201.2. In this particular case, the evidence that the defense points to has to do with juror questions, and the court will, I think, without a doubt, everyone will agree that juror number 1 asked a substantial amount of questions. Now, to be fair, other jurors and alternates, although they don't know they're alternates, also asked a substantial number of questions. For instance, juror number 181, whom had the medical issue today, also asked a copious amount of questions. What we know about juror number 1 is he's a former law enforcement officer. We've known that since day 1. That's on his juror questionnaire. Everyone's known that. And certainly he survived the individual questioning, then the group questioning that we had for all of the jurors. During the course of this trial, I mean, obviously I said juror number 1 has been asking a lot of questions, and I don't know, maybe 3 or 4 weeks ago, the defense started referencing their concern about this particular juror. And certainly I've been paying attention both before, but acutely aware of each and every question that comes from juror number 1. The case law that's been cited to the court From the case for the defendants is the Allberger case, and the best case, if you will, from the plaintiffs. I think it's, where did it go? It's the Washington v. State case, which is 955 Southern 2nd, 1165. Judge Padovano, writing for the first DCA, talks about witnesses who ask probing cross-examination questions, and how that is not necessarily any indication that the juror has violated an order or instruction of the court. You know, the court's instructions, you know, can't form any final opinion. You have to keep an open mind. 9 weeks into this trial, I can tell you without any sort of certainty that juror number 1 has been testing the evidence in this case. Every single witness. Well, I don't think he asked a question today, but I think he asked a question on almost every single witness that wasn't by deposition. And the witness, even after the defense 3 or 4 weeks ago started pointing out what they were contending to be prejudgment, this juror continues to ask probing questions. If he had already made up his mind, why would he ask so many questions? If he had a final or fixed opinion, why would he continue to do this? Now, yes, he put a lot of prefaces into it, but I would say that his prefaces talk about context. And we have to remember that the jurors asked their questions after all of the lawyers, and perhaps this is bad on me, but I did not constrain the lawyers to a strict direct, cross, and redirect. I let them go for recross and redirect and recross until the lawyers were finished with their questions. That's just because I view this as a let's find the truth. And so I didn't want artificial boundaries on cross-examination and redirect to limit us. So the point is, sometimes it might be an hour and a half, 2 hours or so, or if we've taken lunch, even longer, before the jurors were able to ask their question. And if they use, let's talk about this subject, and without providing context to the question, you know, he might have written it down 2 hours before. So this juror was providing context. I have not seen anything in my mind that would remotely come to me to get to the conclusion that he has prejudged anything in this case. Yeah. On the contrary.
So the judge is with me in basically saying this motion is ridiculous, which I think it's completely farcical. It's a farce of a motion. I'm half surprised the judge isn't sanctioning Johns Hopkins for this. This is ridiculous. All the case law that's out there, and we read some of it, and they pointed this out in their reply as well. Like, all the case law that's out there deals with jurors as they're asking questions before they're seated, right? As part of the voir dire process, right? In which case you have a lot more discretion to exclude a potential juror for bias, right? The case law isn't dealing with a juror who's already seated. The rules are different once the juror is already seated. You can only throw them off the jury for cause. You can only throw them off because they've engaged in improper behavior. They've done independent research. They've been independently, examining the case, going to the crime scene. They lied in their written voir dire, maybe, or they lied during their oral voir dire. Or they're a statutorily ineligible juror. They're not eligible to be a juror at all. Somehow they managed to get through the process, but you're just now figuring that out. So, you're looking for misconduct. You're looking for them actually. So them asking harsh and probing questions isn't going to do the trick, right? And it's like you sat this juror. You asked the questions. You did the voir dire. You sat this juror. This juror is just asking questions. They're asking probing questions, and even if they have an opinion, as was pointed out by the case law, and we saw it in the Court of Appeals when they were writing about it, as they brought out in their reply. Right? It's unrealistic to think the jury is not going to have any opinions. They have opinions about witnesses, and they can. They just can't have a final conclusion as to the case. They can't have that ultimate conclusion, but they can think, this witness sucks, or this witness is good, or this witness is credible, or I agree that that's what that exhibit thinks, or I disagree with that exhibit thinks. That expert says that picture shows that traffic light is green, but I don't think it is. I think that traffic light's red. I disagree with the expert. Whatever it is. I don't think, that witness says that they could see that guy clearly, but they had to view him from, 100 feet away at night, with no glasses, right through a moving L train. I don't think they could do that, right? So they can have opinions about witnesses. They can have opinions about evidence. They just can't have the ultimate conclusion. And at 9 weeks in, it's like, yeah, they're going to have an opinion as to which way, they're leaning. And even if they go into the jury room with their mind made up, as long as they're willing to hear their fellow jurors out, they're still not in violation of the rules. As long as they're willing to engage with their fellow jurors and have a discussion and actually do, deliberation, every member of the jury walks in with something, and sometimes they don't walk in with the same opinion. As long as they're willing to try to get to the end conclusion, they're not violating any rules. The thing is absurd. It's absolutely ridiculous. The motion was ridiculous, and it was shameful, and the fact that Maya's attorneys were this close to conceding it, is mind-blowing. I mean, they must be absolutely dead tired, is the only thing that makes any sense, because, the judge is like, this is ridiculous. I'm half surprised the judge allowed argument on it. I really am. I'm half surprised the judge had argument. I would probably dismiss this summarily, because it's just crazy. I don't need to hear argument. It's ridiculous. I can decide this on the paper. It's like, okay. But Jack over here, the client, in the blue tie with the shirt, with the snazzy jacket, is the only sane one in the room.
I am warmed by the fact that he has, in his mind, gone through, or what I believe to be his mind, based on the questions that he's asked, my observation. I mean, the guy sits, 5 yards from me. I've been watching him for more than 2 months. I mean, he's the closest juror to my physical vantage point and location, and I've been watching the guy, and I have no. Not only do I not have a doubt, I don't have a reasonable doubt, but I have no doubt that this guy has not come up with any final or fixed opinion. And when I reviewed the motion, the only thing that gave me any hint of an issue was the reference to the shared cultural sense of Beata Kowalski and this witness. And I went back and looked at the actual question that was asked, and I don't see anything in here where this witness suggests even remotely that he is going to vote for the Kowalskis because of that, or vote against the Kowalskis for that. To me, it's just context. He was providing a situation of how he was framing the question. And then I go back to, this is a person with law enforcement background, and he's, in my mind, taking what is sharply conflicting evidence that both sides have skillfully and artfully put forward to this jury, and he's trying to make sense of it. Now, there was a reference in the motion to, is he communicating? Obviously, there's no communication in the jury room every single break, even if it's for 2 minutes. I ask if they've been talking with each other, and the answer is no. So I have no concern.
Congratulations on the new
that
job,
there's
Holster.
any hint of deliberations or discussions amongst the jurors back in the deliberation rooms outside of the court's presence. So I don't see that as the case. So the only evidence here is his demeanor in front of me, plus the questions that he's asked. And I don't even get to the point of whether I need to discuss whether I need to have a conversation with him, because I'm not even close to the question of whether I have a reasonable doubt as to whether he can be fair and impartial, whether he has violated any court instructions. And I've seen no evidence that he has violated any court instruction. On the contrary, I think he's been doing exactly what we've asked the jury to do, which is, if they are so inclined to ask questions, and he's using his skill and expertise as a former law enforcement officer to do that. And that doesn't mean asking sharp questions, as Judge Padovano points out in the Washington case. That doesn't mean that the juror has come up with any sort of final or fixed or violated any instruction of the court. So I don't think I need to say anything more on that. So I'm going to deny the motion to remove juror number 1 from the juror. Juror number 1 will remain on the juror. The alternate, number 106, the retired electrician, will remain as an alternate.
Well, yeah, so that's pretty much the end of that. And again, I as much as I'd like to think this is some sort of like 4D underwater hungry hippo, no scope move by the attorney, I'm not going to give it that much credibility. I just think it was dumb. So, and if my options are option A, this was a sophisticated work of genius performance art, or option B, the attorney did it stupid, I'm going to go with option B on this one. The attorney did it stupid, and Jack is the hero. That's what I'm going with. Yeah. If my options are 360 no scope, underwater hungry hippos, and the attorney did a stupid, I'm going attorney did a stupid. So that's what I'm thinking about. You think it was all calculated by the jury consultant? You think the jury consultant like calculated this like yes, no, yes thing? To what end? Okay. I mean, you think that I mean, I respect Ruby. Ruby is a professional and she's in a position to know. So I'm just astounded that that this was you think that this was all planned by the jury consultant in some sort of, I guess, plan to sow confusion. Okay. All right. Okay. I mean, all right. That seems odd, but fine. It's I suppose Ruby is in a better position to know. She's actually been in court with the man, so all right. But all right. Ruby is good people. Let's read some super chats today. That will bring us to the end, by the way, of the stream time. That's all the things I want to share with you for the summary. So we covered the motion this morning with the exhibits and the unforced errors with the do you want rebuttal or not. We listened to the cross-examination of the rebuttal, which was fun. We listened to the jury instructions on the intentional infliction of the emotional distress, plus the self-deletion, discussed the law a little bit on that. And we also reviewed the should juror number 1 be excluded with whatever that was, which I suppose you can judge for yourself on whether that was intentional or not. So we had a very productive day. Stephanie 1208 became an uncivilian. Thank you for hitting the join button. Haley Turney became an uncivilian. Thank you for hitting the join button. Palmyra Productions became an uncivilian. Thank you for hitting the join button. Shika became an uncivilian. Thank you for hitting the join button. Becca Lynn became an uncivilian. Thank you for hitting the join button. Mindy HB became an uncivilian. Thank you for hitting the join button. My dog Clover became an uncivilian. Thank you for hitting the join button. Maria Z gifted 10 gift memberships. Thank you very much for gifting memberships to people. Twisted Tragedy gifted 10 gift memberships. Thank you for gifting memberships to people. Laura Christine gifted 20 gift memberships. That's very kind of you. Thank you very much. Solo YOLO became an uncivilian. Thank you for hitting that beautiful join button. Baby Gator gifted 20 gift memberships. Thank you very much for sponsoring other people's memberships to the channel. Gooey or Guy maybe, Seppi gifted a membership. Thank you very much. Becca Lynn gifted 5 gift memberships. Thank you. My dog Clover gifted 5 gift memberships. Thank you very much. Glow T gave $9.99 to say you're the best. Thank you. I try. Polly Claire said for £5, but there are billy goats and maggot hiding the documents. Yeah, I don't know if that works as an idea, but we appreciate it anyway. Jules Buddha, longtime supporter of the channel, $10. Good to finally catch you live after the time switch, brother. Sorry we were busy with work, but tried to catch you on replay. Yeah, this is just a one-time thing for Monday because Rob was out of town and Ian wasn't streaming, so we will still be on Thursday, so don't panic. This is just an extra thing. So you're still getting the normal amount of streaming with Uncivil. This is just bonus stream. This isn't weekly news roundup. This is let's discuss the stupid of the Maya Kowalski case, which is also fun. Jules Buddha gifted 20 gift memberships. Thank you very much for that. That's appreciated. Fiber Tornado gifted 10 gift memberships. Thank you very much. Gail Schmidt became an uncivilian at the $5.99 level. Well, that's very, very nice. Becoming an uncivilian at a higher membership tier. That's very, very kind of you. Thank you for joining at the $5.99 tier. That's really, really kind of you. CeeLo gifted $4.99. Did you say you mean the ghost didn't bring this to you, Dr. Goodhair? Apparently not. M. Young gifted 5 gift memberships. Thank you very much. Tasha Lynn gifted 10 gift memberships. Thank you very much. Victoria gifted 10 gift memberships, or 5 gift memberships. Thank you very much. Tiny Treasure gave a super chat for 99 cents. Roy gave $9.99 to say, hear from Rob, RA, EDB, and others. Thank you for covering this. You're welcome. And I'm glad that so many of you are able to see so many other great creators. And thank you, by the way, to Recovery Addict for redirecting people this way for this evening's stream. It's appreciated. That's very kind of him. And he also had a nice conversation with me recently as I'm trying to figure out, can I stream the Trump trial from Atlanta? We're looking into it. Anyways, Caitlin Fletcher gifted $4.99. Say, just want to say thank you for the recap today. You are most welcome. Road Tech Girl gifted 20 gift memberships. That is 20 people who became uncivilians because of Road Tech Girl. It's very nice. Cool Springs gifted 10 gift memberships. Thank you very much. Lizzie Yordi became an uncivilian for hitting 99 cents by hitting that beautiful join button. That's nice. Who's Handsome has been a member for 3 months. Laura Lenny gifted $2.79. Say thanks for the legal recap. And that apparently was her 3rd super chat ever, so that's very kind. Laura Lenny then gifted 20 gift memberships. Sheree's gift has been a member for 1 month at 99 cents civilians. Stacy Stevens became an uncivilian. Thank you for hitting the join button. Marvin CZ became an uncivilian at the $5.99 tier. That's very nice. Thank you for joining at a higher tier. Bri K gifted 10 gift memberships. KC Cat gifted $5 to say, Kurt, and IG is as bad as it gets. That's my understanding. It means we're almost as bad as it gets. They mentioned something about after that, then people are taking over the hospital, but whatever. It means the possibility of losing Medicare, Medicaid funding, and the state feds coming in and take over. Yeah. KL Burke gifted 10 gift memberships. Thank you very much. They mentioned something about where he implied, at least, that there was something higher than an IJ, which would mean an immediate takeover, but I might have misunderstood. Anyways, KL Burke gifted 10 gift memberships. Thank you very much. Julia Carver gifted $19.99 to say, just saw you last week on Rob's evening stream. So glad I found you. Great perspective. Thank you. You're welcome. Glue Seppi gave £1.99. Solo YOLO gifted $5 to say SS was admitted CA prosecutor. She was biased versus Beata. She also had premonition of Beata self-harm. I can conclude intent for those reasons. I'm not sure if I agree with that, but okay, noted. Thank you for the super chat. Baby Gator's been a member for 5 months. Baby Gifter said, Kurt, I think I'm with you on causation for the self-harm claim, but I think they should win on other claims. I think that's a very fair rationale. Solo YOLO gifted $2. Say on a live note says reason is so they release Maya. Well, that goes to her mental perception, I suppose. So that's something. Laura Lenny gifted $6.99 Canadian to ask, what about social media influence on the live cases? We talked about that a little bit. Wednesday 88 $5 said, without change there can be no progress. If you don't have questions or request change, how do you change? I mean, there's something there, I suppose. Giuseppe gifted $1.99 to say thanks. Red Rogue gifted 20 gift memberships. Rock1234 said, how can the jury decide it was extreme in the absence of standard practice evidence? It'll be overturned on appeal. For extreme emotional disturbance? It has nothing to do with practice. Well, I suppose that's not completely true. There's a lot of reasons this will probably be overturned on appeal. So, yeah. It'll be interesting to see what the Court of Appeals does. Lois Cox became an uncivilian. Thank you for joining at 99 cents. Giuseppe gifted to give membership, and then Leaf Lover Liz has been a member for 8 months. Automata said, et ux, as in uxor, root word of uxorus? I don't know. Laura Lenny says 4D chess move, not checkers, for the legal recap. Thank you for the super chat. Twisted Tragedy gifted 10 gift memberships. Paul John T said, go have a coffee on me and a laugh. Jackie Collier became an uncivilian at the 99-cent level. Thank you very much. Hippo Lover said, thank you for covering this, laughing with you. For $20. It's very nice. Vez from Quebec joined for 99 cents. Thank you for hitting the join button. Miss MZ Wiz joined for 99 cents. Thank you for hitting the join button. Guy Seppi gifted a membership. Hollister74 became an uncivilian. Thank you for hitting the join button. Jolly Rogers, $5. Do you think Anderson did this just to screw with the defense? My personal bet is that he's just an idiot or tired or both. But that's my view. Others disagree. Twisted Tragedy for $5 say, do you realize that the same judge that allowed the IIED came through the Petita laundry parents case? Yes, that has been brought to my attention. That it is the same judge who allowed the Petita laundry case to go through, which I also disagree with. So maybe this judge is more amenable to pushing the law than your average judge. Because I didn't agree with that one either. So maybe this judge is just more amenable to pushing the law. I mean, someone's got to be, I guess. Yeah. Laura Linney gifted, has been a member for 11 months. Thank you. 2 Scoop Destroyer has been a member for 16 months. Laura Ann gifted $9.99. Becca Lynn gifted $5. Say, my comment suddenly stopped going through. I don't know why. Good night, all. See you in RA court tomorrow. Love you all. AT1CVB41 gifted 5 gift memberships. Guy Seppi gifted a membership. Becca Lynn gifted $2 to say, at Alabama Rose. Nope, only my super chats are going through. Becca Lynn gifted $2 to say, at Alabama Rose. I closed and switched browsers and devices. Equality T joined or gave $3 Canadian for a sticker that appears to be a squirrel that says, my hero. Cute. Karate Cop Mom said LNC timestamp for defense jazz hams. I think we will let that go for now because I am tired. So I think we'll let that one pass. But that is where we're at. So that was exciting. So tomorrow morning we'll be closing arguments. And then the jury will get the case, and we'll see what happens. My prediction is the jury is going to decide for Maya throughout. And I think they're going to give a fairly big dollar award. And then we're off to appeal. So The notice of appeal, the notice of appeal is already drafted and ready to go. I'm sure they just need the verdict form to have wet ink on it so that they can file the damn thing. So they both have appeals ready to go. I'm sure they've got it in the drawer ready to go. Someone's standing at the courthouse ready to file it, right? Yeah. How long will they deliberate? Who can say? It's a complex case. They've been doing it for 9 weeks. I don't know how long it's going to take them to deliberate. I'm in no position to answer that question. I think the hospital definitely did wrong by Maya, especially in the period before they had a court order. They did wrong by Maya. They did wrong by taking photographs against her consent. They did wrong by her by sending her into a room, for 48 hours for no apparent reason other than to torture her. They did her wrong by keeping her mother away from her without really any real reason. They did wrong by her by refusing to allow her to be discharged. The hospital simply didn't have the authority to do that. She was stable. There was no medical reason to keep her there, and they had no legal reason to keep her there. So they acted improperly. So they kidnapped her, which we call false imprisonment on the civil side. They did battery. There was medical malpractice. I'll pass on the intentional infliction of emotional distress claim for the moment. But she's had some real damage done to her. And they did it from this position of hoity-toity, we know better, and arrogance that is really unbecoming. And I think Maya deserves some sort of compensation. So, personally, I think, because they estimated something like $8 million, as I recall, at one point for therapies for Maya. And then you throw in some counseling, throw in some counseling and you throw in some punitives. And so I think, an award of, 30 or 40 million outside of the harm to Maya's mother would be an appropriate award. That would be sort of my position starting from, and then I don't know where you go from there. But yeah, the medical malpractice is going to be, a huge driver of it. The other ones are fairly inconsequential. Maybe for the intentional infliction, maybe for the false imprisonment, 3 million including punitives. Maybe for the, I'm speaking for me, by the way, just when I'm answering this. For the false imprisonment, maybe 3 million. Maybe for the battery, 3 million including punitives. The med mal is going to be 30 million probably with punitives. So yeah, treble damages, times 3 is what I'm using for punitives. I'm using times 3 for punitives. Yeah, so you can thank the U.S. Supreme Court case State Farm for that one, for the times 3 multiplier. So yeah, I think it will be longer than 60 minutes. I mean, there's a lot here. There's a lot here. There's a lot for them to go through. It's early in the week. It wouldn't surprise me if they take the week. It wouldn't surprise me if they take the week and they don't have a verdict till Friday. It would surprise me if they go beyond that. If they win, does the lien on their house go away? I don't know anything about the lien, so I don't know. Multi-billion-dollar business, 200 million isn't unreasonable. I think that's the wrong way to think about it. Right? That's the wrong way to think about it. Because it shouldn't matter. well, the way we sort of think about things, we don't. I'm looking at this from the position of what is right for Maya. I'm looking at the position of what damage was done to her, and using some of the numbers like the 8 million that they talked about. So I'm using that piece of information, for medical care. I'm using some sort of off the cuff numbers for, what it might cost for therapy, you know, for going forward. And then just doing a multiplier. I'm not really factoring into this what Johns Hopkins can afford. I'm just trying to look at this from an assessment of what does it take to make her whole. How much money does she need to make her whole? But that's how I'm thinking about it. That's the entire purpose of punitives. Well, again, thanks to the U.S. Supreme Court case State Farm, anything more than a 3x multiplier off of compensatory, you're going to have a problem. So, again, I'm just looking at this from a legal posture. Yeah, I can't unduly soak the hospital. I can't just soak the hospital because I can't inflate the punitives. I can't really, I can't inflate the punitives. The Supreme Court has told me 3x is basically my limit for punitives. So I can't inflate the punitives. So I can only look to compensation in 3x. So that puts a cap on me. $5 from Texas. Katie did, because they lied to my ketamine or opiates. Hold on. Till she ages out. DCF damages for pain. Yeah, sure, all that stuff, for sure. All right, I'm gonna go to bed. I'm exhausted. I love you guys. Bye.